you.
The one I recall offhand, CJ, related to the retirement age in the context of labor law, and what one needs to agree between yourself and your employee, lest you be prevented from asking that person to retire. And the other one related to the abuse of power by Metro Police in the Pretoria area at the time.
Comes easily to you, and I imagine you don't struggle to write judgments.
I think so, CJ. On the last occasion, I indicated that I had written in excess of 320 judgments which were published. Yeah. They've now increased to just under 400 published judgments. So I would have written in excess of 400 judgments since I was elevated to the bench.
That's a huge output. How many judgments have you written in the electoral court? An estimate will do.
I think it's about 4 or 5 or probably 5 or 6, CJ.
I know it's early days yet, but do you know if any of them have been taken on appeal?
Well, there's the one that was taken on appeal is the Labour Party judgment that went to the Constitutional Court. That was upheld. My judgment was upheld by the Constitutional Court.
All right. You have declared certain health issues that are very common, and I do empathize with you because I am in the same boat myself. Does your medical condition hamper your work at all?
No, not at all, CJ.
You manage it?
Yeah, as I indicated to you on the last occasion, I'm on medication for my hypertension and cholesterol. I think it's under control. I see my medical practitioner on an annual basis, and he gives me the assurance that I won't drop dead soon.
I do hope that you follow a healthy lifestyle, because that's more important than the medication itself.
Yeah, I most certainly do. I most certainly do, CJ. Yes.
All right. No, thank you very much, Judge. I'm going to hand over to, welcome, Justice Zondi, Deputy President Zondi.
Thank you, CJ.
You may take over.
All right. Thank you. Good morning, Mr. Adams.
Morning, DP. Nice to see you.
How are you this morning?
Okay, thanks. I hope you are too.
Yeah. I see that in your question you indicated that we had about 4 judgments outstanding. What is the situation now? Have you tried to clear them out?
No, I've handed down all of those judgments, DP.
Okay.
Yeah.
Well, I must just record that I never had a problem with you with regard to the delivery of the judgment at the Electoral Court. The judgment that I assigned to you, you dealt with them expeditiously, and there was no issue with regard to the delivery. And hopefully, should you be appointed, I'm definitely sure that we'll continue to contribute to the Electoral Court.
Yes. Thank you, DP. Yeah.
That's all that I wanted to say.
Yes. Thanks, DP.
Thank you, CJ.
Candidate colleagues. Minister.
Thank you very much. Good morning, CJ. And let me just welcome Judge Adams and wish you well in this process. Let me just start by asking, in 2015, the Constitutional Court criticized you for failing to inquire to the relevant circumstances of the evictees at that time, refusing to rescind the original eviction order that was erroneously granted. And in this, because I'm just, as you know, I'm former Minister of Human Settlements and would have had to deal with the plight of those that are evicted, when they are evicted, a majority of them being women and children. In that regard, and I do believe that this would have put this vulnerable group at risk in terms of not being able to be having a shelter over their head. Do you regret this decision that you took and your exercise in terms of good judgment in this regard?
Yes, thanks for the question, Minister. As indicated, I think, by the GCB, that judgment was handed down very early on in my career on the bench. I was acting at the time, firstly. And secondly, I also, I most certainly have learned from my judgment. In the context of the development of the law at the time, I clearly erred, as was held by the Constitutional Court. And with the benefit of hindsight, I definitely will deal with the matter differently now. The matter was referred back to the Johannesburg High Court, and I'm told that subsequently that matter has been resolved favorably in favor of everybody, including the owner of the property.
Thank you very much. I think the next one that I have, just last one, CJ, it's around the modernization of the voting system. That IEC would have announced that investigating electronic voting to modernize South Africa's elections. And some have argued that there are what e-voting offers a wide range of benefits in terms of that. But there are also those who are arguing around the downside of the digital electoral process. Issues such as tampering and not making sure that there's actually the right to vote by many, especially those that are in rural areas, but also potentially of ensuring or hacking of the systems, cyber crimes that could lead with tampering of the votes and democracy in our system. What is your perspective in this regard in terms of the integrity of our electoral system by the introduction of digital platforms or digital voting, and whether that could tamper with the right to vote or even one vote, one citizen across the country?
Yes, thank you, Minister. I think it's inevitable that at some point we need to progress towards digital and e-voting, but we must obviously be alive to the risk involved. I think the Electoral Commission has commenced the process in the registration of parties and candidates. Must be done electronically, but they have also retained the option to do some of these processes manually. I think there are risks involved in the digital voting process, but I think similarly it has its advantages, and maybe that's ultimately the way that we should progress.
Minister, any more questions for the candidate colleagues? Professor Marumachai?
Thank you very much, CJ. Good morning, Judge.
Morning, Prof.
Judge Adams, I want to ask you a question. I think in the last round of interviews for this court, one thing that concerned me, not in relation to you, but generally, was that it appeared to me that there were some candidates who were not quite familiar with the recent developments in the electoral law or election law as perhaps you put it in your question. I just want to ask you, I want to satisfy myself that you have been acting for a year, that at least you are vested in the development. I'm not sure if you are aware of the amendments that were done in 2003 to the Electoral Act, and some of the requirements in relation to candidates who wants to stand outside the party political structures, and some of the concerns that they had. I want to find out from you, what were the major concerns and how did the Constitutional Court try to address those issues?
Yes, thank you, Prof. I think that the main concerns that the independent candidates had related to the requirement that they needed to have a 15% of the quota of voter supporters to just get onto the ballot, so to speak. And they thought that that was unfair, firstly vis-a-vis the fact that they don't have the necessary capacity to do that. And in fact, they had to do it. If you're going to be standing in any particular province, you needed to get 15%, and which 15% of voter supporters of the quota from the previous elections. So in certain instances, for example, that would have required them to get about 14,000 signatures, names, identity numbers of supporters. And so the Constitutional Court agreed with the independent candidates and said that that seems unfair, and they reduced that and said that all that they need is 1,000 voters for each particular province or each region that they're going to be standing in.
Thank you, Prof. Commissioner Malem?
Thank you very much. Judge, just a follow-up on the last question. What mechanism can we put in place to verify that these 1,000 signatures are authentic? Because they are not being audited anyhow. We just get a name, surname, correct ID number, and then you sign or get different people to sign for other people. How is that helping us if it cannot be somehow verified that these are authentic signatures?
Yes. Thank you, Commissioner Malema. In fact, that was exactly the difficulty that the Electoral Commission had in the Liebenberg matter. I don't know if you're familiar with the matter, but it's Liebenberg versus the IEC. Mr. Liebenberg intended standing independently in some of the provinces, and the Commission has systems in place that is able to verify, firstly, the ID number. They connected somehow to the Department of Home Affairs, so they were able to make the connection and see and verify, firstly, the identity number. And then, so if it's a non-existent identity number, it's thrown out automatically. And then they also have a way of establishing the residential addresses of these persons, and that they got from their systems that indicated that a particular person is registered in a district. And in this case, for example, in Limpopo, when there was an attempt to have them used as a supporter in Mpumalanga. And so they were able to pick that up, and ultimately they then also had investigations done in respect of certain individuals who then confirmed, for example, that they were not the ones that signed those lists of matters. So they were able to siphon out all of the fake, so to speak, signatures. I don't suppose it's foolproof, but it's at least a start, Commissioner Malema.
Judge President Mlambo.
Thank you very much, CJ. Good morning, Judge Adams.
Morning, JP.
Good. You have the title of the resident dean of the faculty at the High Court in Johannesburg. Could you tell the Commission why? Shortly, not very long.
Yes. Thanks, JP. It's a title that you bestowed on me, JP. The reason for that, I'm assuming, is because I'm a member of the Continuing Judicial Education and Training Committee at the Johannesburg High Court, and I convene training sessions on a weekly basis for judges to enhance and advance our skills. And so that's where that comes from. So I would ask other judges to present on topics that is topical at the time, so that we don't fall behind in our education and our skills development. So hence the Dean of the Johannesburg High Court title.
Thanks for that. And I can tell you, acting judges in particular value these sessions. One, I just want your comment. We're battling with backlogs in the high courts and in other courts. And some jurisdictions, like China, when me and the CJ visited them, we found out they were using AI judges. Please find time and schedule a session where we discuss whether we could use AI judges to deal with these backlogs. I don't want to comment.
Yes.
Thank you, CJ.
Thank you, JP.
Thank you, CJ.
Commissioner Pillay?
Thank you, Chief Justice. Good morning, Judge Adams.
Morning, Commissioner.
Judge Adams, I just want to follow up on the question posed by the Minister in relation to digitalization. And I want to tie it into your judgment in the Labour Party matter, which concerned the online candidate nomination system of the Electoral Commission, and whether or not the Commission was entitled to rigidly enforce its timetable for the uploading of candidate lists and supporters lists onto the system. And you had found that the system was fit for purpose and that the Commission was entitled to rigidly enforce it. The minority judgment in that matter raised the question of the digital divide and its impact on inclusivity and its impact on people being able to exercise their right to participate in the electoral process. Now, do you have a comment on that? Because you don't see that reflected in your judgment, considerations of the impact of the digital divide.
Yes, thanks, Commissioner. I must just say that the Constitutional Court agreed that with the approach adopted by the majority judgment, which was my judgment, firstly, and then secondly, I did not mention specifically the digital divide, except that I said in my judgment that the difficulty with the complaints on behalf of the applicants in all of those matters were that they clearly had not done the necessary preparation in order to ensure that they comply with the requirement relating to the uploading of the list. So it wasn't so much the fact that they didn't have the necessary skills, they just did not have the necessary, they didn't do the necessary preparation, and they started their uploading, for example, at a very late stage, which left them vulnerable, and ultimately that is the reason, and like I say, the Constitutional Court agreed with me, but it wasn't a case of them being disadvantaged as a result of their lack of technical knowledge or technological knowledge.
The only issue, Judge Adam, is that your judgment went beyond the facts of that particular case, because you said ultimately, I think you made a finding that the online portal system was fit for purpose. And I think in that context, the minority comes back and says, well, in making that finding, you need to consider that there may well be people who don't have access, and this may impact their right to participate in the political process.
Well, the answer to that again, Commissioner, was that there were alternatives available to political parties and candidates who could, for example, submit their list with the supporting documentations manually. Unfortunately, it was at the office of the Electoral Committee in Centurion at the time, but there was that alternative available to them.
Thank you, Chief Justice.
Thank you, Commissioner Pillay. President Mulemela.
Good morning, Judge Adams.
Morning, President Molamela.
Yes, I've noted that some of your court proceedings take place virtually. Is that correct? For the electoral court?
Yes, yeah. In fact,
Yeah.
most of our hearings were held virtually.
Yes,
We
yes.
just had the one. No, sorry, we had about 3 of the ones that the important judgments or matters we had in person, but the ballots were all held virtually.
Yes, I'm interested in that, your own personal experience. Did it work out well? Were there any challenges? Bearing in mind that you always sit in panels
Yeah.
in the electoral court.
No, President Molamela, not just from the electoral court, but since COVID in our court, we've been doing virtual hearings, and I think we have fine-tuned the process of virtual hearings, especially in our division. I've conducted a few trials virtually as well, and even with the load shedding at the time, we had experienced very little challenges relating to the fact that these matters were being heard virtually. In fact, some of those matters have subsequently gone on appeal, and the record, I'm told, is a lot easier to transcribe than is normally the case. So, yeah, the short answer to your question is that I can't complain of any challenges that we've experienced, especially not during the hearings in the electoral court.
Thank you, Judge Adams. Thank you, CJ.
Thank you, President.
Thanks, President.
More questions, colleagues? None? All right. It appears that we've reached the end of your interview, Judge Adams. Is there anything you wish to raise with us before I release you?
No, just to thank the Commission for hearing me yet again for the 3rd time.
Well, thank you for not giving up. You're excused.
Thank you so much, CJ, and thank you all the commissioners.
Colleagues, shall we go directly to deliberations? All right. May we ask that the room is cleared? Those who are not members of this body, please leave the room. Is the missing NETLEC member here, Secretariat? Did they arrive? Okay, you may call the candidate. Miss Kandidze,
Good morning, CJ.
did I pronounce your name correctly?
Yes, that's correct,
All
CJ.
right. Are you well?
I'm sure I'll be all right.
No, just relax into it. We are
Thank you.
pussycats. We won't be hard on you.
Thank you.
You're an attorney, an admitted attorney, notary, and conveyancer.
That's correct, CJ.
Admitted as such in 2005.
Correct, CJ.
All right. You have 2 degrees, an LLB, oh no, 3, an LLB honors from Forte,
Correct, CJ.
and an LLM in international trade law
That's
from
correct,
Stellenbosch.
Yes.
All right. When did you obtain these degrees?
The LLB one is 2001, and the LLM is 2002.
So by the time you started as a candidate attorney, you had your academic qualifications under your belt.
Yes, I started with my article soon after completing my LLM.
Yes. And you started at Cliff Decker and then went to Chidden Thompson and Hasem and then lectured for a bit. What did you teach?
I was teaching labor law. I taught labor law at the University of the Western Cape for a term, but over and above that, I also taught contract law from time to time as a guest lecturer there as well, UWC.
But that was only for a brief stint.
Yes.
Okay. And you then became director at Norton Rose Fulbright and then decided to take the leap and establish your own firm.
That is so, CJ.
When was that?
I left Norton Rose Fulbright in June 2023, and I started my own firm in July 2023.
All right. How is it going? Have you regretted that decision to
No, not
strike
at
it off
all.
on your own?
Not at all, CJ. I was wondering why I didn't do it sooner. I've been blessed in the sense that there are clients that know me from way back that have just continued to support me. So, yeah, and they were sad, obviously, to hear that I'm thinking of taking this step.
Yeah. What kind of work does your firm do?
It's mostly labor law, CJ, but before I started my firm when I was at Chiddles and at Norton Rose, I also do a bit of procurement law.
All right. When did you start acting as a judge, and in which court was this?
CJ, I've been acting since 2015.
At the labor court?
Yes, at the labor court. I've only acted in the labor court. I've not acted in any other court. So 2015, and then I think 2021 was the next stint, and then 2023 and 2024. So last year, I acted for 3 consecutive terms.
So how long in all have these stints, what do they total up to?
About 30 weeks. I see two of the law bodies did their calculations and they say 30 weeks, and I'm happy to go with that, or 8 months. If you can, yes.
Did you get an opportunity to write judgments during this acting stint?
I've written so many, CJ. As I was preparing for this interview, I thought, how do I go through the 40 or so judgments that I've written to remind myself? But yes, I've written quite a number of judgments.
Any of them reported?
There are two that I'm aware, CJ, that are reported.
Okay.
Yes.
Right. Any taken on appeal successfully?
Yes, so there are two judgments that I did. I think the one I did in 2023 regarding prescription of awards, that was taken on appeal, and the appeal was dismissed. But I have to say it was dismissed on a different point than the one that I had decided. I had dismissed the contempt application on the grounds that the arbitration award had already prescribed. But when the matter went to the LAC, the court took the view that because the employee failed to tender services after the award had been issued, that issue was dispositive of the appeal. So that appeal failed, but as I said, it was decided on a different point. Then the other judgment that I wrote, which was taken on appeal, relates to a Section 197 transfer of a business. I think last month the LAC overturned me, unfortunately.
One of the professional bodies, I think it's the GCB, complains that you did not disclose the details of these judgments, so they were not able to review them. So we have to take your word for.
I saw that, CJ, and I immediately regretted it that I had not mentioned the details. Why I did not do so at the time, I can't explain now, but yes, it would have been of assistance to the law bodies to know about the judgments that I had written, which had been taken on appeal.
You listed 8 reserved judgments in your questionnaire. Have these been delivered?
Yes, CJ.
All of them?
I am pleased to report that all of them were delivered within the 3-month period, except for one judgment which I rendered last week. But it's because the record was quite voluminous. I was sitting with 7 or 8 lever arch files in a review. So it took me a while to get to the judgment. But yes, that went out last week.
How long did it take you to deliver this judgment from the time of the hearing?
The hearing was on the 21st of November 2023, and I handed down the judgment last week, the 28th of March 2025. So that's I think just over 4 months on my calculations.
Sorry, when was the matter heard?
21 November 2024.
Not 23?
No, not 2023.
Okay.
Sorry, CJ.
Okay.
If I said 2023, it's an error. Yeah.
No, it's within time. Do you deliver your judgments timelessly?
I believe I do, CJ.
Well,
often
there are norms and standards. Are you able to deliver them within the prescribed 3-month period?
Yes, CJ. So let me put it to you this way. Obviously, when I started back in 2015, judgments were not going out promptly. And when I joined the system, I just played along and handed down judgments as and when I could. But obviously, since 2023 and 2024, and knowing that the requirement is that judgments must be handed down sooner rather than later, I've tried to make sure that all my judgments go out within at least 3 months. Sometimes I'm even able to render judgments overnight, and sometimes I'm even able to do extempore judgments.
All right. Thank you, Ms. Kandeze. Judge President Mulahleki, first welcome. I forgot to do that when we started. I guess I was a bit cross with the gentleman who's late. One of the gentlemen sitting next to you from Nedlec. So you can blame my lack of courtesy on him. And welcome to the Nedlec members as well. It is your turn to put questions to the candidate if you have any.
Thank you very much, Chief Justice, and good morning all the commissioners. Good morning, Ms. Kandeze.
Good morning, JP.
Are you okay?
I'm all right.
We can't hear you, JP. Would you?
Can you hear me?
I can now.
Oh, okay, my apologies. Chief Justice has touched on most of the questions I would have liked to put to you, particularly around the kind of work that you do. I see from your papers you do about 80% of your practice is labor law.
Indeed, JP.
Now, before we go into the details, you've applied for the position in Cape Town.
I've indicated that Cape Town is first choice because I'm obviously based in Cape Town, so, you know, that would be first choice, but if Cape Town is not an option, then I'm prepared to be considered for a position in the Johannesburg court.
Okay, because there are 3 positions that have been advertised, 1 in Cape Town, 2 in Johannesburg. So you would be willing, if you are successful, and it's so decided to make your main seat in Johannesburg, to consider that.
Indeed, indeed,
Okay,
JP.
thank you very much. And that would entail, as you're aware, the appointment in the labor court, you're not necessarily appointed to one court per se. You travel around.
Indeed.
Generally, you travel 2 weeks per term, but that's not a fixed rule. That depends also on the workload. Now, during your work, your acting stint, how did you find the environment in the labor court?
JP, if you can just be a bit more specific, environment in terms of the kind of the work?
In terms of your engagement with the other judges, attending tea.
Yes.
You may have seen in the acting judge's manual, we do emphasize attending tea, and somebody who reads it may think, these people want to go to tea. So how do you find, what's the value of that?
No, there is great value, JP, in going to tea, because my experience has been that we talked about the cases that we were doing, and I remember many years back that, especially us as acting judges, we were encouraged to attend tea, because that is the opportunity that you have to speak to permanent judges.
Sorry, my apologies. Apologies, Chief Justice.
Yes, no, that's all right. To speak to permanent judges and other judges about whatever matters that you might be working on. But it's also an opportunity to know your colleagues. In fact, I think it's the only opportunity to know your colleagues, because you arrive in the morning, you're busy with your files, and you go to court, you're busy writing judgments during the day. So tea time is the opportunity that you have to mingle with your colleagues. So I found that very, very useful.
Yes. And I looked at the recent acting stint. You acted between 14 August to 15 September. You acted again 1305, 2024, sorry, and 2023 to 2106, 2024. And again, you acted 2608 to 2009, 2024. I looked at some of your judgment. You seem to have delivered them all within the required time. And you've also mentioned earlier that you've picked up in terms of ensuring compliance with the protocols.
Indeed.
And how did you manage to get to that?
JP, there is no other way to say this. It's just a lot of work. You work most of the time, but unfortunately working hard comes easy for me. I don't mind. I would rather sit there and be working than sit around and do nothing. But I also have to say that in the time that I've been acting, I've interacted with permanent judges who have specifically mentored me and said to me, you need to pick one day a week where you take a break, whether it's the Saturday or the Sunday, and I've tried to apply that, but most of the time you are working all the time, unfortunately.
Okay. I take it during your acting stint you've covered most of the spectrum of the cases that are handled in the labor court, particularly your urgent court and your unopposed motion. Those are the most challenging courts.
Yes, indeed, I've done that, JP.
You have done that.
Yes.
And the urgent court, did you do it under the new system of the court online?
Yes, JP, I did that when I was on duty in Cape Town. Remember, when you are in Cape Town, if you're on duty doing motion court, then you are also responsible for doing urgent applications. So yes, I think I had 1 or 2 urgent applications that were brought in through the new system. And when I was in Port Elizabeth, no, I think no, I didn't have any urgent
Port Elizabeth
applications.
was still
yeah.
lagging behind. It
Yeah.
was just catching up in as far as that is concerned.
Yeah.
But how did you find that the use of the new system? Is it helpful? Is it causing delays? Is it putting more pressure on the judges?
I think it's definitely helpful for the judges because you have everything on your laptop. You carry your laptop with you everywhere you go, and so you are able to refer back to the documents that the parties were relying upon without having, to lug around with a big suitcase. But in my experience, I think the attorneys are still struggling. We've had cases where the people would come to the registrar and say, really, I'm here, and I've got the hard copies of the documents, and the judge is here. Can't you just give the judge the documents? So I've noticed that's creating a problem. It's creating a problem for attorneys, but it's also creating a much bigger problem for unrepresented litigants.
Okay. I can assure you that problem, particularly in Cape Town, has now been addressed by the Technical ICT Committee.
All right.
And have you done any case or virtually?
Yes, yes. In fact, the one trial that I did in Joburg, I think the beginning of November, we didn't finish it the Friday, and the following week I was scheduled to be in Cape Town doing motion court. And because Monday is a reading day, I then opted to continue with the trial on a virtual platform from Cape Town because the representatives are here in Johannesburg. So yes, I have.
Okay, I'm pleased to hear that because in Johannesburg now, we've set up a proper and fully fledged virtual court.
Okay.
You simply walk into that court and every screen and every screen is set up for you.
All right.
And we're looking forward to that. CJ, I think that's all I would want to ask.
Thank you, JP Mulahlehi. Commissioner Matolo-Tlepu.
Thank you, CJ. Good morning, Ms. Kazize.
Morning, Commissioner.
Okay, I'm just interested, with issues of transformation and empowerment. I see you have done your LLM in international trade law.
Indeed.
And in 2002, have you ever had an opportunity really to practice in that? Or do you ever get that opportunity to practice in that?
No, unfortunately not, Commissioner. And as I indicated in my questionnaire, I think, in my 20 years of experience, there are only 2 matters that I got involved in where international trade laws were implicated. But other than that, I've not been involved in, I can't say I'm practicing in international trade law, no.
But I'm just trying, why I'm curious is that, is it because you never got an opportunity to practice in that type of law, or you never had a chance? Yeah.
Commissioner, I think when I finished my LLM, I went to Chidul, Thompson and Haysom, and they don't exactly have a department there that works on international trade law matters. So obviously you work with what you have. Yes, you work with what you have, and when I was at Norton Rose, I was in the Labor and Employment Law Department again. I don't know that they have a department dealing with international trade law. So yes, I think it's a case of I just haven't seen the opportunity to get involved in international trade law matters.
Thank you, CJ.
Thank you, Commissioner. Professor Marumachai.
Thank you very much, CJ. Good morning, Ms. Kagitse.
Good morning, Commissioner.
I want to ask you about something that I find very, very interesting, and I think you delivered a judgment on your bundle of documents.
Yes.
I'm not sure if the bundle that you have is paginated, but the one that I have is not. So it's page 32 of the bundle. It is a case of Forsman versus Mpeshu Property Investments Pty.
Yes.
Yes. I'm quite interested in this judgment because the world of labor or the world of work is changing so drastically that we find it difficult to know who is the employer, who is the employee, and to define the workplace itself. And in this matter, you are dealing with an issue at the gym and the person who's working there and trying to understand whether the person was an employee or the person was an independent contractor. If you go to paragraph 103 of that judgment.
Sorry, I beg your pardon, paragraph?
103.
103.
103 of the
Thank you.
judgment. You list various common law tests that were there to determine who is the employee. And then immediately after dealing with that, you go into the submissions of the parties. What I want to understand is, because before you deal with the various tests, you actually provide the statutory presumption that assists us to determine who the employee is.
Yes.
And when I read the judgment, I'm not quite sure whether, because ultimately you find that the person here was an independent contractor as opposed to an employee, and thus the court will not have jurisdiction for obvious reasons.
Yes.
What I'm struggling to understand is, I'm not really sure for you to reach that determination or that conclusion, you applied the common law tests or you applied the section 200A of the LRA, in other words, the rebuttable presumption provision. I'm not sure if you would recall, but when the court determines who the employee is, what is the actual test that is applicable? Are you looking at the statutory test, or are you looking at the common law test? In other words, is the common law still relevant in determining who the employee is, given how those 7 factors that determine who the employee is are actually structured in the Act?
Yeah. Thank you, Commissioner. So to answer your question, the approach that I took is one where I took into account Section 200A of the Labor Relations Act, and then I also considered what the Code of Good Practice on who is an employee is, and then I also look at case authorities, and as you rightly pointed out, what you refer to as the common law is what's dealt with in the case authorities, where I said, even though the dominant impression test has received heavy criticism, ultimately the courts, they've accepted that is the test that you ought to take into account. In other words, you look at the totality of the circumstances, and you apply everything. You apply what's in Section 200A of the Act, you apply what's in the Code of Good Practice, as well as the common law test to say, taking into account everything, do you say this person was an employee or an independent contractor? And after applying all of that, I came to the conclusion that, in fact, the person was an independent contractor as opposed to an employee.
Okay. Can I follow up, CJ? I guess my question is not necessarily to that effect. What I'm asking is, when you look at Section 200A and the 6 or 7 factors that have been outlined there, they take into account the control test,
yes,
the dominant impression test, and the organization test. So when you look at how they have been structured, they codify the common law. So what I'm asking you is it still necessary for the court, when determining who the employee is, to refer to the common law test? In other words, is there any value still to deal with the common law, while the statute actually gives you a rebuttable presumption as to who the employee is?
Yes, I hear you, Commissioner. I guess the problem with what's in the Code of Good Practice and what's in the Act is that it just gives you factors that you need to take into account. And where the common law comes in my respectful view, is that the common law tells us that take into account all of that. It's not a tick box exercise where you say, because I've ticked A, then this person is definitely an employee. I've ticked B, the person is definitely an employee. The common law test requires us to look at the totality of the circumstances and say, taking into account everything. So to answer your question, yes, definitely the common law is still very much relevant, and I think it still needs to be applied. when you are determining whether a person is an employee or an independent contractor.
Thank you very much, CJ.
All right. Chairperson Tsweni-Tsipan.
Good morning, Ms. Kanditse.
Morning, Commissioner.
I must say, Ms. Kanditse, your journey is an inspiration to many young women out there. At the age of 46 years, you've already attained so much for yourself. Now, please briefly tell us, who is Mr. Piwa Cecilia Kanditse, starting from your childhood ages?
Starting from my childhood age, so I was born in Zimbabwe. I grew up in Zimbabwe in a village, and then went to boarding school for my high school, and then went to Fort Hare University Tertiary Education in 1998. I don't know whether that covers what you want me to cover in your question, but in a nutshell, I come from very humble upbringing, and I've had to work my way up to be where I am today. I don't know if that answers the question.
No, I think I'm happy with your response.
Thank you.
At least we do have the gist now.
Thank you.
Who are you? Now, my next question will then be, by its nature, the labor disputes are adversarial, but alternative dispute resolutions mechanism like the mediation and arbitration, they do play a crucial role in the labor law. How do you see the role of the labor court judge in promoting effective dispute resolution beyond litigations?
Yes, I do think that as labor court judges, we definitely do have a role to play, and I will speak from experience. I've heard files before me, and I go through the files, and I go through the issues, and I then say to the parties, it seems to me that the real issue is actually issue X, and it seems to me that if the parties can go down the passage and have a conversation about it, you're actually able to resolve the matter. And in my experience, that has actually worked. Parties come back to me and say, thank you, Judge. We've actually had a discussion about what you proposed, and we've resolved the matter. Mediation, I know it's not provided for in the Act, as I can recall. I think that's a function that's offered by the CCMA. But I do know from many years back, when I was involved in some strike-related disputes, that we would appear before a judge in the labor court, and the judge would propose that the parties explore mediation before resorting to litigation, and it worked in some of those cases. So I think mediation definitely has a role to play in resolving labor disputes.
Okay. No, thank you very much, CJ. No follow-up.
Thank you, Commissioner. You mentioned that you were born in Zimbabwe, and just to make sure that we comply with the Constitution, which requires judges to be South African citizens. You are a South African citizen.
I am a South African citizen, CJ.
Yeah, I thought so.
Yes, I am.
When did you acquire that citizenship?
2016, 2017, somewhere thereabout.
All right. Thank you, Ms. Kandise.
Thank you.
President Mulemela.
Thank you, CJ. Good morning, Ms. Kandise.
Good morning, President.
Have you ever been in a situation where you were involved in a review application and discovered that the record was incomplete? And if that is the case, how did you deal with it?
Yes, President, I know that there was a time when the case authority suggested that if an applicant places or asks for a review application to be enrolled in circumstances where the record is incomplete, there was a time when the approach of the labor court used to be to just dismiss the matter. But I do know that with I think the practice manual from 2013, there were then provisions in the manual to the effect that if the record is incomplete, then the judge president can be approached for directions on how the matter must be dealt with. If it's possible to reconstruct the record, that's an option that can also be explored. But if the record is necessary for purposes of deciding the review and it cannot be reconstructed, then there are matters where matters that have been remitted to the CCMA or the Bargaining Council. So when you ask about my experience, I do know that I think last year, 2024, I had a matter before me where the record could not be reconstructed at all, and the issues that were raised in the review application required me to have regard to what was in the record, and I then remitted the matter back to the CCMA for a fresh hearing.
Or for a fresh hearing?
Yes.
Okay, thank you. Okay, sorry CJ, just a follow-up. And what would you do if only part of the record is missing, not the entire record?
So, President, it depends on the issues on review. If it's an issue that you can decide based on the record that's before you, then I would decide the matter based on that record that is before the court. But if I'm not able to decide the grounds for review based on the record that's before court, then I would first price ask the parties to see if they can reconstruct the record, and if that is not possible, then I will consider remitting the matter to the CCMA or the Bargaining Council. So the answer is it depends on the issue. There are some issues that you are able to decide on review without a record, but there are some issues where your decision has to be supported by what is in the record.
So if the record is incomplete and you are remitting to the CCMA or the Bargaining Council for reconstruction, would you give any directions to the CCMA or the Bargaining Council regarding the reconstruction? And if so, which directions would you give? Or sometimes they are referred to as directives.
Yes, so I would give a directive, but I think it's a directive that I would give in consultation with the parties, because they are the parties involved in the matter and they know more about the matter than I do. So I would say to them, my sense is there is insufficient information for the review to be decided, and invite their submissions on the issues that, or the information or the evidence that's missing from the record that would need to be decided by the CCMA. So I'm saying my sense is I wouldn't give that directive on my own as the judge without consulting with the parties.
Thank you, Ms. Candice. Thank you, CJ.
Thank you.
Minister? Thank you very much, CJ. Good morning, Ms. Kalice.
Good morning.
Just looking at your work that you have done and around the exercises that you've done, voluntary work that you've been able to do, and work around women. But more so for me will go in terms of the issues of access to justice. I hope I'm audible. Let me just bring it closer. The issues of access to justice. In looking at majority of the people, what they have as access is work in the CCMA level, and some of the people are not able to have access to labor court. What do you think should be done to ensure that labor court is more accessible to ordinary workers and as part of making the whole system accessible to South Africans?
Yes. Thank you. My view is already the labor court is doing enough. I know of matters where I sit in court either as, a party representing a party, and an unrepresented litigant gets up in court and they try to address the court. And my experience is the judges have been very understanding and say to the unrepresented litigant, your papers are not in order, and if you are not able to afford the services of an attorney, I would recommend that you go to There's the SARS Law Office that sits, I think I don't know about PE and Durban, but I definitely know they sit in the Joburg and the Cape Town Labour Court. Judges have referred matters to the SARS Law Office to make sure that people get assisted. There are some matters where you can assist as a judge, but obviously you need to be very careful what you do so that you're not seen to be assisting an unrepresented litigant. So if it's a matter where the legal issues are not properly set out in the papers and you can't assist with that as a judge, what I have done, I've also done it as a judge, is to refer the unrepresented litigants either to the SARS Law Office or to the Legal Aid Clinic.
Just to follow up on the same matter, because you've now articulated on the unrepresented litigants. And in this regard, the issue is just broadly, and perhaps my issue is broadly around whether you look in terms of the physical presence of where the courts are, the issues of understanding and being, if I'm a litigant, I'm unrepresented, as you say, I might not be able to represent myself because I would not understand how I should be able to write my affidavit and all that. But more so as well, the cost associated with it, as we look at what the Legal Aid Board is able to offer. A low-income earner who earns below 8,000 currently will not be, or who earns above 8,000 will not be able to get represented, and therefore the above and the category and the affordability. And I want to understand from your view, in terms of having worked with communities, having worked with the most vulnerable, what's your view generally around where we're sitting as a country in terms of access to justice to the most vulnerable of our communities?
Yes. Thank you, Commissioner. Yes, that's definitely still a challenge, and I wish we could do more, but we work with what we have. I want to give you an example. I think last year I had a review application involving an unrepresented litigant who is based in George, and it was a review application, and I received an email that he was requesting that we have the review on a virtual platform as he's unable to travel from George to Cape Town. And obviously I didn't even think twice about it. I just thought that's what we do. But unfortunately, the case involved a review application where there was no review record. There was absolutely nothing before the court, and the litigant stated that because he's unemployed, since he lost his job, he's unemployed, he's not been able to find a job so that he can have the record transcribed. And I understood the situation, but at the same time, I also felt that my hands are tied. If it's a review application and there's no record before the court, unfortunately, the court cannot assist. So you try and assist where you can as a sitting judge, but unfortunately, and demonstrated from the example that I've given, there are just some cases where your hands are tied, even as a judicial officer.
Commissioner Liganyan?
CJ, thank you so much, and good morning, Ms.
Good morning, Commissioner.
Just one question. Where, for instance, the labor court finds that a hopeless case is being pursued, especially by those who are in the senior echelons of state administration, and that weighs very heavily on their juniors, and the court arrives at that determination. Do you think that it is justified that the court can order that the cost must be borne by those that pursued that hopeless case? Thank you.
Thank you, Commissioner. The answer is definitely, and especially where people are legally represented, and they still insist on having a matter litigated, which a court describes as hopeless. I've got no question, I've got no doubt in my mind that people must be penalized with court orders to discourage other litigants from pursuing hopeless cases.
Commissioner Hassan?
Thank you very much, CJ. My name is Commissioner Fasia Hassan.
Thank you, Commissioner.
Thank you very much. I have a different question. In your papers, you spoke a lot about your extracurriculars and work outside of the legal fraternity, related to you being the chair of the Cape Town Rape Crisis Centre, as well as mentoring a young black woman attorney. So I'm just interested if you could maybe expatiate on some of this work around gender empowerment and some of your activism work more broadly, and how it positively or negatively may affect your role as a potential judge in this particular labor court. Thank you.
Yes. Thank you for that question. I must say it's a question that I always anticipate when I sit in these matters. But I can assure you that I've probably written 3 or 4 judgments on sexual harassment matters. When I look at the matters and I write the judgments, I write the judgments based on what the facts tell me and what the law tells me. And I think of the 4 judgments that I have written, there's one involving the I think it's Home Affairs, where an employee was dismissed for sexual harassment, and I came in and I said, it's understandable why a commissioner would find that the employee was involved in sexual harassment, but taking into account the facts of the matter and the circumstances under which the conduct complained about had occurred, I was of the view that the employee could be given a final written warning and return to work. And obviously when I wrote the judgment, I was very much alive to the fact that the department might not be happy about the conclusion that I had arrived at, because there's, in my view, a misunderstanding that every case involving sexual harassment must be met with a sanction of dismissal. And I expressed a view in that matter that is not so. You must always be guided by the facts of the matter that's before you. So yes, I am an activist, but at the same time, I know I'm a lawyer at heart. And when I sit in these matters deciding which way to go, I apply the law, and I leave my activism at the door, so to speak.
Commissioner Moiman?
Thank you, Chief Justice. Greetings to yourself and fellow commissioners and Ms. Kandize.
Yes, thank you, Commissioner.
Thank you. Just one question from my side, which relates to one of the judgments that you referred us to, Mugwazi versus SAT.
Sorry, I beg your pardon, Commissioner?
Mugavazi versus South African Airways Technical.
Yes, that's in my pack, yes.
Yes, that is the case that I'm more interested in. 2 areas or objections that were raised by SAT. One on the two cause of action emanating from the same set of facts.
Yes.
One that Ms. Mukavazi filed an individual claim alleging unfair dismissal based on discrimination. Then the second one, the matter brought by her union, NUMSA, following section 189A.
Yes.
Kindly just explain to me the distinction that you brought to make a pronouncement on those 2 objections that were raised by SAT.
Yes.
Thank you.
Thank you, Commissioner. The first one, as I recall it, was that, maybe let me just go to to the facts, just so there is context. So a number of employees were dismissed following a Section 189 process, and NUMSA then referred a dispute to the Labour Court, seeking to challenge the dismissals. But what Ms. Mgavazi then did was she referred the dispute to the CCMA for conciliation, which is a box that must be ticked before the Labour Court can have jurisdiction in these matters. So at the Labour Court, the referral that was made by NUMSA was challenging the substantive and the procedural fairness of the dismissal, and had nothing to do with discrimination. And remember I said that Ms. Mgavazi referred her dispute to the CCMA, and that matter was conciliated, and in those proceedings she specifically raised the issue of discrimination. So when the matter came before me, the employer sought to argue that, in fact, this matter is already pending before this court. And I think at the time the Labour Court had actually dismissed NUMSA's claim on whatever basis, I can't quite recall, and the matter was now with the Labour Appeal Court. So the approach that I took was to say, but the matter that Ms. Mgavazi has brought to court is one that relates to a discrimination. Obviously, she's also alleging substantive and procedural fairness, but she's also alleging discrimination, whereas the dispute that NUMSA had referred to the Labour Court did not involve a discrimination. So that was one of the issues. I can't remember the other issue. But yeah, that was the least pendant point that was taken by the employer, which I dismissed.
Thank you, Ms. Candida. Thank you, Chief Justice.
Commissioner Trolley?
Thank you, Chief Justice. Good morning, Ms. Candidze.
Good morning, Commissioner.
In your description of your legal background, you mentioned the good fortune of being assigned to, during your clerkship, to work with the late Mr. Tim Mills.
Yes.
What motivated you to mention this, and what was the most beneficial experience of working with him?
Yes, so Mr. Mills is the director that I worked with when I was at Cliff Decker doing my articles, and I think the first 6 months I was allocated to him. It was, for me, just such a pleasure working with him. It wasn't just work, it was work and playing. He gave me opportunities to draft papers. He sent me to court with counsel. He sent me to consultations with clients, and I could see that he genuinely believed in my abilities to be able to do the task at hand. And obviously after the first 6 months, I then moved on to the other departments, but I wished I could go back to him. And I guess I can say maybe that's when my love for labor law developed, because I really enjoyed working with him. And I must say, when I was interviewed at CTH, they wanted to see if I was capable of drafting, if I drafted any heads, if I drafted any affidavits. And I just went back to the documents that I had drafted in the first 6 months of my articles with Mr. Tim Mills, and presented those to them at Chiddles, and they were convinced that I was capable of doing the job of a labor attorney. So yeah, he left an impression on me, and yeah.
Thank you, Chief Justice. Thank you.
Commissioner Mangena?
Thank you, Chief Justice. Good morning.
Morning, Commissioner.
Good. I need to ask you a question regarding the matter of Payne versus Department of Education.
Yes.
You were dealing with a complaint arising out of unfair discrimination.
Yes.
Yeah. The referral was made in terms of Section 51 of the Employment Equity Act.
Yes.
And a point was raised that that's actually an incorrect usage. The correct section to use should be 1581G of the Labor Relations Act.
Yes.
Now, but in the course of your judgment, in paragraph 36 of that judgment, when dealing with that point raised by the respondents, you said that you are not able to dismiss or uphold that point and dismiss a case because the litigant relied on an incorrect statute.
Yes.
But then when you gave the order, you actually upheld that point, that the applicant relied on an incorrect statute. So I find that to be a bit contradictory.
Commissioner, if you can just bear with me. I definitely know that I did say that I'm not going to dismiss the review application simply because an incorrect provision of the Act has been relied upon. But what I said in the, if you can just bear with me to go to the order so I can see the contradiction that you are referring to.
At which page of the record is this?
Page 102, paragraph 1.
Yes.
It says the review application ought to have been brought in terms of section 158(1)G of the Labor Relations Act and not section 51H of the Employment Equity Act. So, excuse me, where is the contradiction?
In paragraph 36 of the judgment.
36.
Because the respondents had actually argued that that review should not succeed because it's brought in terms of a wrong act, but also a wrong section.
Yes, so in paragraph 36, I'm basically saying the review ought to have been brought in terms of section 158(1)G of the Act, but it was in fact brought in terms of section 50 of the Employment Equity Act. So I said it doesn't matter, the fact that they've relied on an incorrect provision does not change the fact that this court still has powers to review rulings issued by the CCMA. So I'm not quite sure where the contradiction is, unless I'm still missing something.
Oh, okay. So as you understood it, the fact that the proceedings emanated from the CCMA
yes,
actually gave you the jurisdiction to entertain the review, notwithstanding that the applicant made reference to a wrong section.
Yes, so I did say section 158(1)G is a provision that allows the Labour Court to review rulings. But in that matter, the review application had been brought in terms of section 51H of the Employment Equity Act, which does say that if I recall, it's something to the effect that the court can also review decisions made in terms of the Employment Equity Act. But I was very specific to say where you are dealing with a section 10 claim, a discrimination claim in terms of the Employment Equity Act, that same provision tells us that you must process those disputes in terms of section 158(1)G of the Labor Relations Act, and that's what I did. So I said I'm not going to dismiss the review application based on a technicality, because whether you do it in terms of section 51H or section 158(1)G of the Labor Relations Act, the point is the Labour Court still has the jurisdiction to review rulings.
Thank you, Chief Justice. My second and last, if I may. And this one is very innocent.
I hope so.
If you are sitting as a Labour Court judge and you find that you do not have jurisdiction, do you dismiss the review or you strike it off the roll?
Yes, thank you for that. I would strike it off the roll, but having said that, I do know that there's an LAC judgment that says sometimes judges dismiss the matter, but strictly speaking, it's not dismissing. You're striking the matter off the roll, except that in a case of jurisdiction, I don't know, striking the matter off the roll suggests that you can re-enroll it, but you can't re-enroll it if the court doesn't have jurisdiction. So, yeah.
Thank you, Chief Justice.
Commissioner Nkonyan?
Good morning, Ms. Katide.
Morning, Commissioner.
I am impressed by you having achieved LLB with cum laude in my alma mater in Forte, as well as, of course, what you have already told us you have done. And again, I see that if you are successful, you may be a walking encyclopedia, as it were, for 24 years. Now, my question to you, which I need to preface in this fashion. In South Africa, we do have many foreign nationals, Chinese, for instance, that were convicted here in Gauteng, and for having flouted our laws. And there were also some people that were involved in a building in Western Cape that collapsed. Now, my question is, in the stint that you have been involved in labor matters, did you come across any matter involving foreign nationals? And if so, are you able to share with us your experience, and as well as how you would deal with this matter, because it is a matter of concern to all South Africans, of course, including yourself as a South African. So can you just give us some indication how, whether you had such experience? If you have not, perhaps in future you come across a case of that nature, what would be your decision along those lines? Thank you, DJ.
Yes. Thank you, Commissioner. I think the question you're asking me is related to the question that the other commissioner asked me about my activism work and whether that's likely to influence me when I write my judgments. And the answer that I gave then stands. But having said that, I'm not aware of any matter that I've worked on where there were foreign nationals involved. Maybe they were, but if the papers do not refer to the fact that they're foreign nationals, I have no way of knowing that they are foreign nationals. But what I did indicate in my questionnaire is back in the day, there was a discrimination matter that I was requested to assist with through the SASLO Pro Bono office involving foreign nationals. And obviously when I represent people, I represent everybody, whether you are a foreign national or you are a South African. And when I sit as a judge, it's the same story. Whether you are a South African or you are a foreign national, I'm just applying the law. That's what I do. I look at the facts and I apply the law to the facts.
Thank you, CJ.
Do the NEDLEC members have questions for the candidate? Yes, go ahead, sir.
Thank you, Chief Justice. And commissioners. Ms. Kadise, one question, I mean, you were asked about conciliation and mediation.
Yes.
At NEDLEC, we've just agreed now in the amendment to the Labor Relations Act to put a provision that requires the Labor Code to involve itself in mediation and conciliation. Now, the question is, do you think that process can help in reducing the backlog in the labor code?
Definitely, Commissioner. Any dispute resolution system that does not involve litigation will definitely be of assistance to the parties themselves, because then you get an outcome sooner rather than later. But it will also assist in terms of the backlog that you spoke about. We have the backlog because there are litigants waiting to be heard. And if those matters can be processed through a system other than litigation, such as mediation, then it will definitely assist.
A second question to Chief Justice is that we at NEDLEC agreed and published the amendment to the Code of Good Practice. I'm not sure have you got a side of it? Do you think, and what's your view in the code, and do you think that it will assist in judges in interpretation of the law in the areas that the code has unpacked further, the one that has just been published for public comment?
Commissioner, to be honest, I haven't looked at the code, so no, I'm not aware of what it says about mediation, so no, I will be guessing, which I won't do.
Any more questions from the NEDLEC members? Yes.
Thank you, Chief Justice. And Commissioners, just to apologize first, I have been outside since 9 in the morning. I think I did greet the Chief Justice when she came from the VIP side. I was sitting in there. So I wanted to clarify that I have been outside.
So you did not keep us waiting?
Not at all. I did ask, and I was told there was an electoral court session that was going on earlier on, and I have a memo from the Secretariat that told me that it will start at 10:50, written by Deboho. So I have been sitting outside.
JSC proceedings are very fluid. You never know when you'll finish with a particular candidate. So if you are expected to be here on a particular day, you must set that day aside so that if you are needed at any time, you do not keep everyone here waiting. I do take the point that you were here at 9, but when the Secretariat looked for you, when it was your turn to come and interview these candidates for the Labour Court, you could not be found. That said, you are forgiven.
I have no questions for the committee.
You may put your question.
Oh yeah, thank you very much, Chief Justice. My name is Mkoma Zitwala, representing Labour in NEDLEC. Well, my question, Mrs. Kandinze, is that our Labour Court is a critically important component of our judicial system, and its current functioning or dysfunctionality has a serious impact on the lives of thousands of workers who rely on the CCMA and the Labour Court for justice when they are mistreated and illegally dismissed by employers. And of course, the reports that we're having is that there is quite a huge number of backlogs of Labour Court cases that obviously have an impact on workers. May I ask, how do you think the situation can be improved in the Labour Court so that we deal with the backlogs that are there of cases? Thank you very much.
Yes. Thank you, Commissioner. I am aware that in the Labour Court, they have introduced a system where practicing attorneys are requested to assist during recess with mostly interlocutory applications, just to make sure that you get through the workload. But what I've also done personally, sitting as a judicial officer, is that sometimes a matter comes before you, and for whatever reason, the employer does not want it to go on. Maybe they are not ready to argue the matter, maybe the heads of arguments are not on the file, And I say to them, no, I'm hearing the matter, even in the absence of the heads of arguments. You can file your heads of arguments 2-3 days later. I will consider them and I will take them into account before handing down judgment. That's my way of just making sure that, you know, you postpone a matter or you remove a matter from the roll, but that matter is coming back to the roll. So we need to find a way to just make sure that when matters have been set down for hearing, they proceed, unless there is a very good reason why it cannot proceed. So personally, as a sitting judge, I've refused to postpone matters for reasons that I don't think are compelling. And as you say, at the back of my mind, I'm thinking about this employee. Whether they are going to be successful or not is a different story altogether, but everybody needs closure. So I want to hear the matter so that a judgment can be rendered and there is some sort of closure for the affected employee.
Okay, thank you. All right, Commissioner Baloyi, I'm so sorry. Yes, it's your turn.
Good morning, Ms. Ganeze.
Morning, Commissioner.
Yes. Just to go back to the discussion with Commissioner Mangena about the jurisdiction point, and as I understood you, and please correct me if I'm wrong, you seem to either be non-committal about what you would do if you're confronted with a jurisdiction challenge, or you either non-committal or you're wrong when you say that you would strike the matter off. Did I understand you correctly, what your position is on this?
Okay, thank you for the opportunity. I've actually thought about it a little bit more after I gave the answer that I gave earlier on, and I think I want to revise my answer and say it depends on the issue. So if I'm saying the court doesn't have jurisdiction because the referral was made to court late, then I can strike the matter off the roll to give that party an opportunity to then file a condonation application. And once the condonation application has been decided, the matter is now properly before court, which can then determine it. So that's a jurisdiction issue. But sometimes you have a jurisdiction issue such as an unfair labor practice dispute has been referred to the labor court, which should be referred to the bargaining council or to the CCMA. There is no point in striking the matter off the roll. In that kind of a case, I would dismiss the matter so that the party knows that this door is closed. You need to go and knock on the doors of the CCMA or the bargaining council. So I guess my answer is it depends on the nature of the jurisdictional point that's being raised.
Yes. Thank you.
Thank you.
Thank you, CJ.
Commissioner Pillay.
Thank you, Chief Justice. Good afternoon. Good morning.
Good morning, Commissioner.
I just want to take you back to the Mugavazi matter.
Yes.
The SAA matter.
Yes.
And your finding on lis pendens.
Yes.
And if I've got the facts correct, in that case, NUMSA had referred a dispute of unfair dismissal based on the retrenchment.
Yes.
And they contended that the retrenchment was substantively unfair.
Yes.
Then Ms. Mugavazi came 2 months later and she referred a dispute of automatically unfair dismissal.
Yes, it's the main claim, and as I recall, I think there's also substantive and procedural unfairness in the alternative.
That's right. So her alternative claim was ordinary unfair dismissal. Her main claim was automatically unfair dismissal.
Yes.
And the reason that she referred an automatically unfair dismissal complaint is because she said that her selection for retrenchment was based on discriminatory grounds.
Yes.
And bearing in mind this factual matrix, and bearing in mind that in the NUMSA complaint, NUMSA sought reinstatement of all the retrenched employees. And in Ms. Mugavazi's complaint, she sought reinstatement, alternatively compensation.
Yes, I think so. Yes, that sounds right.
And in your view, she would be entitled to relief in both matters?
No. So what I said was the claim that NUMSA had referred to court. In that claim, the court will not decide the discrimination point unless NUMSA amends the papers. And at the time that I was hearing the points in limine, in fact, NUMSA's matter in the Labour Court had been dismissed, and the matter was now sitting with the LAC because NUMSA had not referred the matter to the CCMA for conciliation.
But both matters were proceeding on the same set of facts, essentially the same cause of action, because you're challenging the fairness of your dismissal, albeit on different grounds, and the same relief being sought in both matters.
Yes, you could say that, but one of the things that I picked up on in that matter, which I reflected somewhere in the judgment, is that the employer was obviously hopeful that I would uphold the point, in which case all these matters would then go away, because remember that with the first claim, the Labour Court had already thrown that matter out, and that's why NUMSA was now appealing to the Labour Appeal Court. But what influenced my decision was the fact that the referral made by Ms. Mugavazi is in fact the referral that followed the correct procedure that should be followed in terms of the Labour Relations Act, which is to refer the matter for conciliation first, and if conciliation fails, to then have the Labour adjudicate the matter. NUMSA had jumped that first point, which is why the Labour Court had in fact thrown out the matter. So I decided the matter on the basis that if you want to raise the point in limine that there is a pending matter, that then it's in fact in respect of the referral made by NUMSA that the least pendants point applies, because NUMSA referred the matter to the Labour Court after Ms. Mugavazi had referred the matter to the CCMA for conciliation. So in fact, NUMSA's referral came afterwards. So I was trying to make the point that if you want to say there is a pending matter, you should be raising that point as it relates to NUMSA's claim, because they referred their matter after Ms. Mugavazi had referred the matter to the CCMA.
Your judgment records it differently. It records that NUMSA had made the referral first, and that Ms. Mugavazi comes second. But also, I just want to check with you, if NUMSA has appealed to the LAC, do you not see that as a pending matter?
Okay, so when I say when you say the judgment says NUMSA referred the matter to the Labour Court first, yes, that is correct, but Ms. Mugavazi referred the dispute to the CCMA before NUMSA referred the matter to the Labour Court. So for me, that distinction is very important, because remember, as I said, you don't start at the Labour Court, you start at the CCMA. So if one party goes to the CCMA, which is the correct procedure, and another party skips that process and goes to the Labour Court directly, in my interpretation, you work with the matter that was first referred to the correct forum. So I accept that NUMSA's referral to the Labour Court was made first, but Ms. Mugavazi's referral to the CCMA for conciliation was made first. Then the other issue that you raised, that because the matter is at the Labour Appeal Court, my thinking was Ms. Mugavazi is seeking to pursue an automatically unfair dismissal claim in the alternative, substantively and procedurally unfair claim. And the discrimination matter is not even part of the matter that the LAC is being called upon to decide. So I took the view that she's well within her rights to decide which cause of action she wants to pursue. And so I found that, there was no basis for the points in limine that had been raised.
Thank you, Chief Justice.
Thank you, Commissioner. Any further questions, colleagues? No. We've reached the end of your interview, Ms. Kandidze. Is there anything you'd like to raise with us before we excuse you?
No, CJ, I'm done. Thank you, Commissioners.
Thank you for making yourself available. You may go. what else? There's quite a lot of these other things you do.
Yes.
All right. You hold a BA and higher diploma in education from UWC.
That's correct.
And actually started out as a teacher.
Chief Justice, I'm a bit challenged because you're so far away from me.
You can't hear me?
I'm struggling a bit.
Oh, sorry about that. Can you hear me now?
I can hear you a little better.
Just a little. I've been accused of having a sharp voice. I'm disappointed in myself. You started out as a teacher.
That is absolutely correct.
Following your BA and higher diploma in education qualifications.
That is correct.
All right. And you were once a music teacher.
So what happened was I grew up in the New Apostolic Church, and it's a church that's primarily focused, amongst other things, on music and music development. So I was fortunate growing up in that environment to be exposed to music from a young age. So I would play organ in the church, I still play the piano, and at times I've been invited to play at funerals and at weddings. Sadly, the weddings that I've played at, somehow the marriages disintegrated. I'm not sure whether that has anything to do with the nature of the music that I provided. But anyway, so that's where the love for music came in, and at the school where I was, I would teach music more as one of the elective type segments, but then later when I joined the New Apostolic Church Administration Officer, I held a position, what is called a music coordinator, myself and a very close friend of mine, Jimmy Bourne, and that role was primarily a music teaching and choir conducting role, which obviously resulted in me being a lot more involved in teaching of young musicians. Music is still part of a passion in my life, and something that I explore as part of a hobby that will probably never die.
All right. Well, you then changed direction. You studied for a BA honors in labor relations and human resources management at Rao, and then an LLB with UNISA.
That is correct.
All right, and you left your first love of teaching music.
Yes.
What kind of work do you do? I see in your questionnaire that you've listed labor law and administrative law work, only 5% for administrative law and the rest for labor law.
Yes. So, Chief Justice, I do a lot of labor-related work. So I appear in the labor court quite often. The last I checked, it was at least once a week, at times a little more than that. I get invited to chair disciplinary hearings by various both public and private sector organizations. I get involved in fact-finding investigations. I represent employees who have been dismissed. So it's a very varied spectrum of labor-related services that I provide in that respect. And I have done, to a limited extent, a little bit of administrative law-related matters. But I think the bulk of my practice would be labor, civil litigation, and admin law. And then a big passion for me is the question of land, and perhaps what I believe to be the slow pace of land reform. In fact, just last week, I was fortunate enough to speak at a conference at UNISA on this question of land. And part of the panel at that conference was the likes of the former DCJ Moseneki and various others.
And my segment specifically had to do with the fact that the indigenous people in our country are still landless. So in a nutshell, Chief Justice, that's what occupies my time. And a lot of the work that I do on a pro bono basis. In fact, if I were to attribute a percentage of the work that I do on a pro bono basis, as somebody once said, I will never get rich. And that's probably absolutely true, because I do a lot of pro bono work. I would say up to 40% of my practice would be doing pro bono work.
You've acted at the labor courts since 2022, well, for 2 years, between 2022 and 2024?
That's correct.
Was that for that entire period, or just stints?
No, in fact, it was 4 weeks in 2022, 2022-23, and then in 2024, I indicated incorrectly so in the questionnaire that I acted for 4 weeks, but it was in fact 5 weeks. And that period was split between Cape Town and Johannesburg.
How long in all?
All in all, it would be 9 weeks, both Cape Town and Johannesburg.
Did you get to write judgments during that time?
I did.
How many?
Altogether, I've counted, I think it's 29 judgments. And together with the judgments for the period that I acted in the High Court acting was 22 weeks or thereabouts.
Yes.
39 judgments in the High Court. So just under 60 judgments over the last 2 years.
When did you act in the High Court?
In the High Court, I acted in Johannesburg as well as in Pretoria.
When? In
2022, 2023, as well as 2024.
All right. So you were hopping between the Labour Court and the High Court?
Indeed.
Okay. When was your last acting stint?
My last acting stint in the Labour Court?
No, anywhere. In any court?
It would have been towards the end of last year. I think in October, JP Lambo had called me and asked if I can please assist. I think it was for a week or two. And I went through and I assisted in the High Court in Pretoria.
All right. You listed 6 reserved judgments from the High Court when you submitted your questionnaire. Have those judgments been delivered?
All of them have been delivered.
All right. You also indicated that you had parted matters as well.
Yeah.
Or was it just one?
No, there's one particular part-heard matter. In fact, I'm not sure it's fortuitous, but that matter is proceeding tomorrow in the High Court in Johannesburg.
So there is progress there.
Yeah, perhaps let me just qualify why that has happened. The registrar that was assigned to me had tried unsuccessfully to set the matter down on previous occasion, and each time that she set it down, one or both of the counsel would be unavailable. I then escalated the matter to DJP Sutherland, and he asked me to set a final date for that trial, or the continuation of that part-heard trial, and it continues tomorrow until Friday.
All right. Are any of your about 60 judgments reported?
Yes. In the High Court, I speak under correction. I think there's 2 one specifically, and in the Labour Court, the Lesedi judgment. Now, ordinarily, for instance, in the Labour Court, what I would do when I've done my judgment, I would consult with the senior judges in the Labour Court, like then Judge Van Niekerk, as well as Judge Mushwana, and share the judgment with them and ask them to guide me in terms of whether or not for them trying to amend what my conclusions are, the legal conclusions are, but to see whether insofar as form and structure the judgment was sound. And after such an occasion, when both of them had indicated that they believed the judgment is sound, I then noted the judgment as not reportable, if I remember correctly. But when the judgment was eventually released, it was then reported. I speak under correction insofar as the process that was followed in how the judgment eventually became reportable. And then the same happened with Ulofso versus Ngobo in the Johannesburg High Court.
Any of your judgments taken on appeal?
Yes.
And what was the result?
In the, I've attached the West Bank matter, the West Bank versus Maseko. That judgment was taken on appeal, and the appeal court had found that, in essence, perhaps if I can just give a bit of context in that particular matter and why the appeal court felt
Briefly,
that.
please. Very briefly.
Very briefly. Well, Mr. Maseko had approached a financing institution to ask for a loan. When he had done so and filled out all the forms, he was then informed that he will be advised that his loan would be approved. And in doing so, he needed to supply certain forms of security, like his banking statements, etc., a number of other things. Pursuant thereto, he then discovers that he actually sold his vehicle. And that he sold his vehicle and simultaneously bought his vehicle back for double the price. That then took me by surprise, and the evidence simply suggested that there was somehow a simulated transaction. The full court felt that I had strayed because I ought to have confined myself only to the fact that there was in fact a contract that was concluded, and I ought not to have considered anything wider than what actually transpired, and then set that decision aside.
All right. Okay, you have disclosed a medical condition. Is it under control?
It is under control.
It does not interfere with the execution of your duties as a judge? Well,
it would not interfere.
As an advocate, rather. All right. Okay, thank you very much, Advocate Ford. Judge President Mugatli, do you have questions for the candidate?
Thank you, Chief Justice. Good morning, Mr. Ford.
Good morning, JP.
Just let's pick up on the last point which was raised about the appeal, but there is another appeal matter. I think it's NMC versus RAF.
Yes.
And the judge who penned the first judgment, you referred to the same judge, I think it's Judge Dlamini.
Dlamini, yes.
Sitting with Judge Fisher and Judge, I can't recall the others, but they commended you in the approach you adopted in dealing with the issue of expert witness in as far as that matter is concerned. Is that correct?
Yes, that is in fact, and thank you so much for reminding me, JP, that was a road accident fund matter. And the view that I took there was that an expert, you know, the old adage that says the person who pays the piper calls the tune, ought not to apply in circumstances when an expert witness is called to testify. So yeah, I had forgotten about that particular judgment.
Thanks for that, but I see that when you got admitted, you started off doing mainly RAF. What informed the shift from RAF to Labour?
Yeah, JP, it's a strange situation, I think, that referral advocates find themselves in, because as referral advocates, we are exposed to the briefs that we are allocated. And I suppose the first time I was given an RAF brief, it was a bit challenging for me, because my background had been Labour, and my first love had been Labour and still is. So it came as some difficulty for me to make that shift from labor to the road accident fund related work. It also caused me to read up on road accident fund related material, the act, the regulations, and that is how I then started getting involved in road accident fund litigation.
Okay. And I see you just said that you appears in the labor court at least once a week.
Yes.
It seems to be quite a significant period spent in the labor court.
Yeah. As I say, JP, my practice is largely labor court driven, both in respect of trials, the occasional unopposed motion, the opposed motions, and on average, that's not to say that, for instance, this week I was in the labor court. I wasn't, but last week I was in the labor court. Yes.
Okay. And I see also that your main time is now spent in the CCMA representing parties in the arbitration hearings.
Yeah. I generally only, or mostly, not only, represent employees in CCMA proceedings. I remember one of the attendees at the conference last week says that it is so sad to see that justice and access to justice has become a commodity that can only be afforded by the very wealthy or those who litigate using state resources. So I generally mostly appear for employees in the CCMA.
Okay. Now, just correct me if I'm wrong here. My notes are indicate that you said that there are no reported judgments in matters that you were involved in.
Yeah, not
I'm
that
trying to contrast that with appearing in the labor court all regularly.
Yeah, I couldn't find the reported judgments, JP. The judgments are well published on SAFLI, but they're not the status of a reported judgment. So in most of the matters that I've appeared are in fact
they would appear on SAFLI.
On SAFLI.
Okay.
But not in the traditional law reports. So certainly not unless somebody points it out to me. Yeah.
Okay. And you indicated that you have one outstanding part head in the High Court.
In the High Court.
You have no part head in the Labour Court.
I've got no part heads in the Labour Court now.
And reserved judgments in the Labour Court more particularly?
I've got no judgments outstanding in the Labour Court. JP, you would recall the only one issue that happened is that sad situation, Le Franschhoek. And that I fully explained what transpired there in as far as what caused the delay in the issuing of that particular judgment. But all judgments in the Labour Court have been finalized and delivered.
Yes, quite understandable, and I guess we can disclose that it has to do with the way the judgment was emailed.
Correct, yes.
And you thought it had gone through when it was lying in your outbox.
Exactly.
But let me ask you this question, because the policy at the Labour Court now is that every time you write a judgment, soon thereafter, the secretary will start sending you emails to remind you. You did not receive those emails.
I did not receive any email. In fact, when I did receive the email, and that was what triggered my response, because I knew the judgment was completed in fact, shortly after leaving Cape Town, I completed the judgment. So I was quite stunned and surprised when I saw that email, and immediately thereafter, literally within a day, if not the same day, I sent through the judgment.
Yes. And what's your attitude towards secretaries sending you reminders? Because arising from your case, I called the secretaries and I said, what's going on? We agreed that you will remind your judges of this. Now, one told me quite specifically that one judge, when he said, Judge, according to the policy, I'll be sending you a reminder, an acting judge, he said, I don't want to be disturbed. What's your attitude towards it? I see you laughing.
I think it is, firstly for me, it is welcoming to be reminded, because I will never be so arrogant, and I hope nobody is so arrogant to say that you remember all things, because we are human beings, we forget things.
Yes. And I see there's one complaint against you, which has gone before the first stage of the committee, and the committee dismissed it. It's now before the appeal. And as I understand, that complaint relates to you refusing to overrule Judge Mushwana in a ruling where he directed that the matter be referred back to the CCMA for transcribing the record.
Yeah, JP, I'm not so sure, because I think day before yesterday, or was it not towards the end of last week, I did receive communication from the JCC informing me that the complaint has been dismissed in its entirety. I then contacted the Secretariat and asked them please to ensure, if it's possible, that that complaint and the outcome of the ruling of the JCC be circulated. Yeah.
Thank you. And tell me...
Chief Justice, if I could help the candidate and Judge Mlahle, it was circulated, and the Objections Committee also commented on it. You've been totally cleared.
Thank you, Commissioner.
Oh yeah, sorry I missed that. I just got distracted for a second here. He's absolutely right. And I must declare as well that I was once involved in that complaint. Not that it matters.
Thank you very much. Now, let's come back to the acting. I see you acted for about 8 weeks in the Labour Court. There's a total period you've acted.
In fact, it's 9 weeks when I calculated
Oh yeah,
the
you
last
said that it was 9 weeks.
Yes.
You didn't act before 2023, because I tried to look at the records and it was difficult for me to see if you had in the previous years acted at the Labour Court.
I did not.
You did not.
I have, though, made myself available for acting. I did communicate with your predecessor, but I didn't get any responses there too. It was only from 2023 that I then got responses to act. I was always able and available to act in the Labour Court.
Okay. I guess that problem, you know, now it's been addressed through the ensuring that the acting is done by a committee, and that preferably you need to be recommended by the law bodies. So there's a process that needs to be done now, rather than speaking directly to the JP.
Yes.
Okay. But now, in the period that you've acted, have you done urgent court?
I have.
And you did it on Court Online. I guess you would be familiar with Court Online from the High Court.
From the High Court, we've been using Court Online, but when I did the urgent role, we didn't do it in Court Online. It was still manual.
Okay. So that was before the
transition, yes.
And tell me, have you seen the latest directive that's coming through into effect on the 14th of April relating to the implementation of the Court Online system, and what's your view in terms of its implementation?
It's to be welcomed, JP. I think it's a move in the correct direction. For me, given the nature and the scope of the Labour Court, what's always a concern is how we accommodate the underrepresented, the indigent and the poor, in making sure that they are not left out in the digitization that we're pursuing. But insofar as making it as a judge, it's such a useful tool to have all your documents centrally aligned, accessible. It is really a move in the right direction, and it's certainly something that I would encourage.
Okay.
And compliment you, by the way.
And have you done any matter on the virtual court?
Yes, I have.
Okay, so you are familiar,
I'm familiar
with the court.
with it.
Okay. And you acted for 22 weeks, from my calculation, in the High Court, 8 weeks in the Labour Court.
Yes.
In that period, have you done an opposed motion, particularly in the Labour Court? Because the unopposed motion in the Labour Court is slightly different from the High Court.
Yes, so the unopposed motions in the Labour Court is a bit of a mixed bag, as opposed in the High Court, you deal with a lot of insolvency-related matters, bank matters, summary judgment applications, whereas I found that the unopposed motion court, because in the Labour Court you don't have like what we have in the High Court with your special interlocutory court, so everything is then, to the extent that it's unopposed, will form part of your unopposed role. I think the unopposed role in the Labour Court, given the fact that the matters are so diverse, I found a bit more challenging at times than the unopposed role in the High Court.
Thank you. And I see you traveled only once to Cape Town.
To Cape Town, yes.
You are aware that the Labour Court does judges travel around the country. You have no problem with that?
Not at all.
Because it's likely to increase now that we're extending the footprints in the other provinces. So you wouldn't have any difficulties with that?
None whatsoever.
Thank you, Chief Justice.
Thank you, JP. Do the colleagues from NETLEC have questions for the candidate? No? All right. Commissioner Marumakhai?
Thank you very much, CJ. Good morning, Advocate Ford, I'm here.
Oh, good morning, Commissioner.
I was quite pleased to hear that you are doing quite a lot of pro bono matters, which is quite important really in the labor space, because of the fees that are involved and the difficulty in going through the various forums before you can even get to the labor code. There is one issue that is likely to be experienced by those kinds of clients who don't have the financial means to take matters to any of the tribunals before you go to the labor code. And this goes into the breach of trust when you are dealing with issues of dismissal. I'm not sure if you are aware of the Labor Appeal Court case that dealt with how you have to negotiate the issue of breach of trust and whether or not it can be a ground upon which dismissal can be found. I just want to ask you this question, whether or not you are familiar with that decision, because it was quite interesting as to how they dealt with the concept of intolerable in the context of what I'm talking to you about. Can breach of trust in the employment context be a ground upon which a dismissal can be found? If yes, under what circumstances?
Yeah, I suppose, I think trust is a vital, if not a indispensable part of the employment relationship. But that trust should be a mutual trust between the employer and the employee and vice versa. The Code of Good Practice in the Labour Relations Act had indicated that where in circumstances the employee commits an offence and that offence renders the trust relationship severed, that in such circumstances you would be able to terminate or dispense with the employment relationship. Now, what I often see is that, and I'm talking from my experience practicing in this field, is that any complaint against an employee is somehow placed under this umbrella of you've committed X and therefore you've breached the trust relationship. The trust relationship must go to the heart of the instances where you would have been required as an employee to act in a manner that is honest and upright in your dealings with your employer. But you can't have a timekeeping problem and have the timekeeping problem be equated to a breach of trust. I'm not sure whether you follow what I'm saying in that regard, Commissioner.
I do.
Yes.
No, thank you very much, Judge Ford. Thank you very much, CJ.
Thank you, Professor. Any more questions, colleagues? Chairperson?
Thank you very much, CJ. Good afternoon, Advocate Ford.
Good afternoon, Commissioner.
Now, the South Africa's labor market is evolving with challenges like automation, your remote work, and the gig economy. How should the labor court adapt to ensure its jurisprudence remains relevant in addressing the modern employment disputes? That's the question.
Yeah. So, yes, I think automation, digitization, all of that have become a reality, and it's a reality that's going to be with us, and none of us can escape it. The labor court, and I remember when I listened to Justice Savage when she sat in the seat that I'm sitting now, explained how important an institution the labor court is. It's an institution. It's important for our economy. It's important for our labor market. It's important for socio-economic and political stability. And the labor court has acquitted itself extremely well in adapting and dealing with automation, in dealing with various types of employment scenarios. And you have a very skilled team of competent judges that have acquitted themselves exceptionally well in dealing with this. And I think the labor court is by virtue of some of the initiatives that the JP has introduced, and such as Court Online and the like, on the right footing, and it should ordinarily be that a labor court should act consistent with the manner in which we acted previously, and consistent with the LRA and the Constitution. And I submit, in that regard, the labor court is well on track.
Thank you very much for the response. The initiatives that you spoke about, are they being adequately resourced?
Yeah, I think I can speak from both the practitioner's point of view and from a acting judge point of view. As a practitioner, we are happy when we see some of the initiatives that the labor court under the leadership of the JP has introduced. And because I used to work with Judge Molahleri at the CCMA many years ago, it's the same sort of trajectory that I experienced when I worked with him at the CCMA is what I see in the labor court. There's continuous engagement, continuous information sharing, continuous outreach to practitioners for ideas, commentary, etc. So I would think from a practitioner's view, in terms of what is being laid out, is consistent with ensuring that the labor court acts in a resourced capacity. Now, as an acting judge, and I think one of my biggest concerns, and it may very well be a concern that the JP has addressed, is the unrepresented. So whenever I sit in the labor court, I will firstly ask the parties who are represented to deal with their matters first. And then, when the unrepresented are left in the room, I have done it, and I've seen many, many other acting judges and judges do it. they would then take their time, and often the court staff who work with them would use their time and place themselves at the disposal of the judge, sometimes working into their lunch breaks to ensure that assistance is given to the unrepresented, in order to ensure that this ethos of the labor court being a court of equity is not only spoken about, but it can be practiced in reality. I hope that answers your question, Commissioner.
No, thank you very much, Advocate. My next question is with regards
just a reminder, Commissioner Mtsweni and other commissioners, it's 2 questions per commissioner. And in the rare event, a follow-up question may, at my discretion, be allowed.
But the second one was a follow-up question.
Was
from
it?
what you said, yes.
Or maybe I got confused by the long answer from the candidate.
Oh, yes.
Okay, put your question and you try to keep him short.
All right.
Good.
Now, my next question is with regards to delays in resolving the employment disputes, which can, in my view, can have severe impact on the financial and emotional finances of the employers and the employees. Now, what practical steps would you take to improve the case management and the efficiency in the labor court?
I remember during the last stint, I had a discussion with the JP in his office, and he pointed to some files in the corner of his chambers, and he was working through them systematically. And I then indicated to him, when I saw what he was doing, to say that there must be a way in which the judges or the acting judges can assist in that process. And the obvious, and I think it's a valid concern expressed to me, was we're short of judges, and we don't have the luxury, and that's why he, as the JP, and I was quite humbled by that, was working through those files. So I think, firstly, the appointment of additional judges would help with the backlog in the labor court. But in terms of what one can do to ensure that labor disputes are expedited, I think, and if I may express an opinion here, Chief Justice, I think for me personally, you have a situation where you have a dual referral system of disputes, which causes serious and unnecessary delays for poor employees. Let me explain it. An employee is dismissed. He then fills in what is called a 711 referral. And within 30 days, the CCMA places that matter on its roll for conciliation, subject to allowing the parties to object to CONARP. In CONARP, it simply means if no objection is filed, the matter will then proceed to arbitration. The employers invariably object to CONARP for no reason, simply objecting, no qualification. Now that poor employee must now fill in another form and wait for another date for arbitration. Now, had it been that one process was set down, then whether you object or not would not mean that the process comes to an end, and have that poor employee having to fill in further forms in order to get the matter resolved. And those are some of the difficulties that I think from a practical point of view might help in reducing the time limit spent. The other factor, Commissioner, is this. I assisted an employee who was dismissed in 2019. It's 2025. That matter is still not resolved. Everything that we've done, every step of the way there's been challenges, it's now going to the Constitutional Court. And it goes directly against the objects and purports of the Labour Relations Act.
No, thank you very much, Advocate, and thanks, CJ.
Good afternoon, Advocate Ford.
Good afternoon, Commissioner.
Yes. I have a question for you arising out of the Lesedi local municipality versus Mpele.
Yes.
The one that dealt with embellishment of the qualifications.
Yes.
I got a sense that you were sitting as a reviewing judge, reviewing an award coming from the CCMA, where the commissioner had actually found that the dismissal was substantively unfair, and the municipality then reviewed that award. Now, the basis for your order was that the commissioner had misconceived the inquiry, in the sense that he did not assess the evidence correctly. Now, my question to you is, does an assessment of an evidence go to the actual decision making, in the sense that is it an error of law or a reviewable irregularity?
Yeah. Yeah, so Commissioner, so we guided by which I can say the two pillars when we deal with labor reviews. The one is Sedumo. We simply asked the question whether the decision that was made by the commissioners one a reasonable decision maker could not reach. Then since Sedumo came Harold versus Nedbank, and in that decision the SCA simply said that what must be demonstrated is whether or not the commissioner or the arbitrator misconceived the nature of the inquiry and thus arrived at an unreasonable result. So when unpacking the Lesedi decision is to unpack that misconception of the inquiry simply further, meaning if one steps back and asks yourself, what would a reasonable commissioner do? And then answer the question by saying, what is typically required in an inquiry? And what would then constitute a misconception of that inquiry? And what I then laid out in Lesedi is, when arbitrating a dispute, you would follow a particular process, and you would then follow another process in arriving at a decision. The one process is the process that is formalized in allowing you to run the arbitration proceedings, such as calling witnesses, etc., etc. The other procedures is that which happens in the mind of the decision maker. I think the decision, if I remember correctly, by I think it's Justice Wallace, he said, you then deal with what we called latent irregularities versus dialectical irregularities that points in the direction of what happened in the mind of the decision maker. Now, when I considered the totality of the evidence that was presented, and the totality of evidence presented was that this particular individual held himself out to have these qualifications, and he does not have them. From that sense, if that was the evidence, then you look at what the evidence was and what is the eventual outcome. And if the eventual outcome competes with the evidence, then an inference can be drawn that the decision maker misconstrued the nature of the inquiry, and that gave rise to an unreasonable result. So in that regards, my conclusion was that the decision maker had misconstrued the nature of the inquiry, when one considers the evidence that was presented and look at the outcome that was eventually arrived at.
Thanks for the answer. But we know that litigants should not actually conflate review and appeal. And as far as I can recall, labor courts deprecate litigants who appeal under the guise of, or review, and, or appeal their awards under the guise of review. And when I read your judgment, I got an impression that I got an impression that the municipality had actually disguised itself in review when they were actually appealing the decision, because failure to assess an evidence, it's an error of law, isn't it?
No, absolutely. The failure to assess the evidence could be an error of law, but it could also point to a misdirection, and that misdirection, and the important qualification, Commissioner, is this. When you look at the eventual outcome, and you contrast that with the evidence that was presented, and it may not even be that the outcome is correct, and that is not what under a review court is concerned with, whether the outcome is correct. The outcome is the outcome a reasonable outcome? Now, when you have a situation where somebody claims, I've got all these qualifications, and the evidence that was presented before the commissioner points to the fact that he does not have that qualification, or the professional qualifications he claims to have. And for the commissioner then to make the transition from there and say, look, I still find that this dismissal was unfair. For me, having considered the evidence, was a bridge too far to cross. And I submit under those circumstances, I concluded that the commissioner had misconstrued the nature of the inquiry, which gave rise to an irregular result.
Thank you, Chief Justice.
Commissioner Balui?
Thank you, Chief Justice. Good afternoon, Mr. Ford.
Yes.
Yes. Mr. Ford, you have given us one judgment and 2 awards, in fact.
Correct.
Now, you would know that part of what we do in assessing candidates is to look at the work that they have produced, and then that's part of the assessment, that tools rather that we use. Now, the one award is a 2002 award. I don't see that it is helpful in any way, and I'm prepared to accept that since 2002 you have evolved, as we all do, and we've grown in the way we do things. And then you've got the next one in 2011. The 202 one is a straightforward dismissal dispute for fraud, and the 2011 is there was a debate about the admission of evidence that was unlawfully obtained, right? And then you've got the Impele one, Lesedi, that you've just discussed now with Commissioner Mangena. Now, the Lesedi one is about dishonesty, inflation of qualifications. It's not clear to me, it's not obvious to me why and how you would have selected these 2 awards in the judgment to convey what to us. Firstly, because it's not obvious to me, because they involve issues, everyday issues. There's nothing in particular that I thought is new and complex in these. I've already said to you the 221 one might just as well discount it, because that's in your early days, and I'm sure it's not reflective of how you write today. So the question is, what informed how you selected these? Why have you not given us more recent judgments? Because I see you were in the Labor Court, and you've listed about 24 matters. Why it is that you've not given us any of that work?
Yeah. So, Commissioner, let me start by answering your last question first. The matters that I considered reportable in the Labour Court, you may note on the schedule that forms part of the papers that I've indicated those are in fact reportable, but they have not actually been reported. Now, I accept full well that the arbitration award, in fact, the 2002 award, I think it was when IMSA had disintegrated, John Brand then somehow got some of us involved to start AMSA and had indicated that AMSA awards would become, to the extent that they meet certain criteria, become reported. And the issue there had to do with, and it may sound like it's a normal run-of-the-mill case, but it had to do with the question of attempted fraud. And when you read that award, I then go into depth to dealing with the concept of there can't really be a legal concept such as attempted fraud in circumstances where the person acted effectively alone. So the idea was to share with you a decision that was reported, and that decision is by no means a judgment, but it is a reported decision. Similarly with the 2011 decision, and what I wanted to demonstrate there was that it had to do with the question of unconstitutionally obtained evidence, and whether or not that somehow affects how that evidence ought to be treated within the context of Section 138.10 of the LRA. And that was really the context within which it was presented. And then the Lesedi judgment. The other reported judgments are judgments in the High Court, the Ngobo versus Ulofse decision that has to deal with when and how an interim payment can be made on a second occasion. I submit I can't take it any further than that, Commissioner.
I guess what I'm raising with you is that on what you have provided us, it is very difficult, at least for me, to conduct a proper assessment of your written work. I mean, you speak of reported judgments, but in fact, in the Labour Court, you've indicated about 3-4 judgments as reported or reportable, written judgments, in fact. Yes. And only one of them has been provided to us. I'm more interested in your recent work, not your 2002 work.
No, and that comment is as well accepted, Commissioner.
Thank you.
Safe to say that those judgments are in fact available. They may not necessarily be reported, but they are published on SAFLI.
Thank you, Mr. Ford.
Can I make a follow-up? Yes, thank you, Chief Justice. I mean, why then did you not submit what is required? I don't understand what you're saying to Commissioner Baloyi. I mean, what are we going to do with an arbitration award when we are trying to appoint a judge?
No, I accept that critique is fairly made. And
I know you've already said that to Commissioner Baloyi. I want to know why you submitted it.
Commissioner, I thought I'd explained why I've submitted it. Do I accept, in hindsight, that that particular award and David's decision does not assist this committee? To the extent that I presented those simply to demonstrate the nature of the issues that I've dealt with in that arbitration award. But I'm by no means saying that they are judgments. So in essence, for purposes of determining whether or not they are judgments that would assist the JSE, I would say the JSE may very well disregard those two decisions. but that the decisions as indicated in the schedule, which I've marked reportable, which may not necessarily be reported, that those decisions are in fact available, and if possible, the Secretariat, or I can make that available to the Secretariat to make it available to the Commissioners.
You see, that's the problem I'm finding, Advocate Ford, is that the application form tells you what you should do, give us judgments. You then decide, well, I'll give you arbitration awards. When Commissioner Balo is asking you about these awards, you say, well, disregard them. Then you say, no, the form says, give me reported judgments. You don't give us reported judgments, you give us report-able judgments. And then when I ask you about that, you say, well, I can collect them and give them to you. So it seems it's a bit chaotic, the manner in which you are dealing with your application. And it's making me unsettled. So maybe you can help me to relax my mind.
So Commissioner, let me assist in this way by simply stating that one award was attached, in fact 2 awards, one dating back to 2002, the other to 2011. The reported judgment is the judgment of Lesedi. The judgments that are noted in the schedule are simply reportable judgments. So in essence, it will only be one reported judgment and the others are reportable.
That should have been the answer, isn't it? Just give us the one judgment and then don't try to embellish it with other things.
Minister? No, just to follow up and take the matter further from Commissioner Nkaitobi. I noticed that in your response in the questionnaire, you either opted to use one word or just give a short answer that didn't give detail to issues, and I can go on. I mean, just even on the issues around articles that would have been written, what proportion of your litigation work has been, no explanation, you just gave the percentage. Can you just explain in terms of how you handled this process of application? Because either Advocate Ford, you didn't have time, no, you didn't take this process serious enough to dedicate time to give us what is needed for us to be able to make a decision. And that's what it goes to, how you would have made a judgment of putting what is required by the questionnaire versus what you are now explaining in this commission.
Commissioner, the explanation that I gave does not seem to undermine the proceedings or the fact, confirm or point to the fact that I did not have time. The questionnaire, as presented, is not embellished. It's simply responding to the questions. In hindsight, the only judgment that should have been reflected there would have been the Lesedi decision, because that is the reported judgment. The other 2 are the reported arbitration awards. When the questions are set out in the questionnaire insofar as whether any of the articles or articles that I've written, were they ever published, or I've answered those questions, whereas the answer might be straightforward, the answer is true.
Commissioner Pillay?
Thank you, Chief Justice. Good afternoon, Advocate Ford.
Good afternoon.
May I ask you about your Civil Aviation Authority judgment?
Yes.
That you handed down in, I think, in February this year. And it seems to be that the judgment was handed down in the context of a leave to appeal.
Yes.
And you took the opportunity then to vary your order in relation to one of the grounds of leave. That's correct?
Yes.
What I find interesting is that in doing that, Advocate Ford, you don't reference what method you used to vary your judgment. In other words, which rule you were applying or how you were applying that rule. what you do is that in response to the leave to appeal, you then vary your judgment, and then you point out that the parties may want to reconsider the basis on which they appeal your judgment because of the changes you effect.
Thanks for the question, Commissioner. Perhaps a short explanation. The Civil Aviation sought to review and set aside a decision, both in respect of substance and fairness. During the course of that presentation of the argument, I then pointed out that the Civil Aviation Authority seems not to be challenging the Commissioner's conclusions around his findings on procedure. And it was then confirmed that, in fact, they do not challenge the Commissioner, apart from, I think there was one note somewhere in the statement to say that, but it was, it was almost a nebulous reference. It wasn't a specific reviewable ground. I found that the case presented by the Civil Aviation Authority was sound, and that I concluded that the Commissioner had committed a reviewable irregularity insofar as the substance of the dismissal is concerned. But that I found that since the Commissioner's decision insofar as procedure is not challenged, that what ought to follow is that part of the Commissioner's ruling will stand. What then follows was a calculation error in terms of 12 months vis-a-vis the amount set out in the arbitration award. So when the variation was then done, was simply to say that the order, insofar as the variation is simply to correct the calculation and limit it within the bounds of Section 194 to 12 months, because in the manner in which it was set out in the initial judgment, it would have been something like 13, 14, or possibly a longer period. So all it was done, I didn't see how an appeal court should be saddled with a calculation error. And that is the reason why. So the context for the variation is explained in that decision. And as matter stands, I'm not so sure whether I should speak on it, because that matter is the subject of an appeal before the LAC.
The only question I had, Advocate Ford, was which rule you applied, because it's not clear from your judgment.
Which rule did I apply to vary the judgment?
That's correct. You handed down a judgment and then you subsequently varied it, but you don't reference any rule.
Yeah, Commissioner, I don't have the judgment in front of me, but the variation would be done within the context in which the court allows for variation of rules and orders. I can't remember the specific rule now in terms of the new rules.
No, sorry, Chief Justice. I'm not sure if Commissioner Pillay is finished, but I would really like to make a follow-up on this.
Thank you, Chief Justice Amta.
Please do.
No, you see, the problem, Advocate Ford, is that I've got this judgment here. It doesn't refer to any rule. What seems to have happened is very simple. I'm not sure why you are not directly confronting it.
Yes.
You made a mistake in the amount you mentioned in your judgment. Then leave to appeal comes. Then you realize that you've made a mistake. Instead of either postponing the leave to appeal and asking for a rescission of some sort, you then decided to combine your leave to appeal with a rescission. And that's why you're being asked, how can you do that when you have to deal with a leave to appeal, which presupposes that you are functus officio? And what you do to avoid the problem of functus is that you just combine a rescission with a leave to appeal. That seems to be irregular. That's what is being asked.
Yeah, Commissioner, my view is simply that the application before me was an application for leave to appeal, but prior to that is the having received the application for leave to appeal, is the simple realization that there is a calculation error. So if there is a calculation error, and insofar as, and you're quite right to say that there's no specific rule set out in the judgment, but if I am not mistaken, and I don't have all the documents in front of me, there would have been a basis on which I arrived at that decision, and that basis, and I speak as far as my recollection can help me, that recollection was to the effect that in circumstances where a judge deals with an application for leave to appeal, he can deal with it in a manner that he sees that he sees fit in order to give effect to the matter being heard without causing any further unnecessary delays to the matter. Because had the process been like you outlined now, for me to indicate to the parties that there's an objective error, they need to bring an application for rescission, etc. Whilst this matter is a very simple one, there's a calculation error, I'm varying the initial judgment to make allowance for the fact that there was a calculation error, and that error is now corrected. I'm afraid I can't take it any further than that, Commissioner, unless there's another question following from there.
Well, I was going to follow it, but as soon as you say I have nothing further to say, I must shut up.
No, Commissioner, I'm not saying I'm certainly not saying that.
No, I'm not going to pursue it any further. I think you've told me that you've got nothing to add, so that's fine. Thank you.
Any more questions, colleagues? Commissioner Malema, then Commissioner Kane.
Thank you, CJ. Advocate, is there a difference between an arbitration decision and a court judgment? If there is, take me through. What are their effect on those cases?
An arbitration award is not an order of a high court or a superior court. Meaning, when a judgment is handed down, there is a requirement that the parties comply with the judgment. There is a requirement that a high court has the type of jurisdiction which the CCMA, and powers which the CCMA, or for this particular instance, the private arbitration institution don't have.
Now, you are being asked for reportable judgments, not reportable arbitration orders. The whole advocate who knows the difference between arbitration order and judgment, you go and write arbitration orders and want to come and create an impression that you have no idea or none whatsoever. You can't make such a mistake. You knew what you were doing when you were responding to our questionnaire, which is in the main misleading. The intention was to mislead this committee. If the attention was not, if we did not pay attention to detail.
Commissioner Malema, I certainly hear what you're saying, but there's simply no need to mislead by providing information that's clearly observable on the face of it. So I've indicated why I added those two decisions. There was certainly no intention on my part to mislead anybody, and I doubt whether anybody was misled. I doubt it very much.
Commissioner Kane?
Thank you, CJ. Good afternoon, Mr. Ford.
Good afternoon.
There's been a weakness identified in your application, and we could capture it as saying that your application is thin I'm giving you an opportunity to rescue one element of it, which relates to your contribution, which you say is in establishing the RSA bar in 2021. My question is, what did you do as a member of the bar prior to that to contribute to the bar? And given that the RSA bar is so new, and you're going to now leave it, notwithstanding that you say your biggest contribution to law really has been the establishment of the RSA bar, you intend to leave it in its fledgling days. How do you consider that to be a major contribution to the law?
Commissioner, perhaps let me step back and say my contribution whilst being at the JSA, because that will sort of lead into why and how the RSA bar was established. I, for a number of years, worked at the JSA in the professional committee. And that was where I made a contribution as part of that committee.
I don't see you mentioning that in your application at all. Am I wrong?
No, that is not mentioned in the application, but I thought that's what you asked. But I can, if I may?
Carry on.
Yeah. What transpired was because, and perhaps I was cautious in sharing that information, was that just prior to COVID, or leading up to COVID, we had an AGM, and if you attended that AGM, you would recall I was speaking at that AGM, and in particular about the plight suffered by black practitioners at the JSA, and the difficulties that they have in having to hold chambers in circumstances where the landscape for them have changed. And then myself, we then recommended a number of interventions in order to ameliorate the situation and to ensure that black practitioners in particular are not castigated or find themselves no longer part of the bar. The response to the proposals I make was very disapproving. In particular, I had proposed that instead of dedicated buildings where members ought to practice from, that they should be allowed to practice from other suitable buildings. And in addition thereto, I proposed that the manner and style in which chambers are held must be revisited and set out in granular detail how that process could work and what ought to be done. That proposal was voted against at the AGM. Pursuant thereto, myself and Ishmael Semenya met and we discussed what next to do. Firstly, to ensure that those who have found themselves at the short end of the stick, so to speak, could be considered. And that is then where the idea of the South African Bar Association was born. And what it sought to do is to achieve exactly the things that we punted for, but didn't get within the JSA structures. To say that, to set up an institution where you reduce subscriptions, where you allow the flexibility of holding chambers in a manner that is still consistent with the practice of an advocate, but not in high-rise or buildings dedicated to the practice as specified. We also then looked at the transformation initiatives in making it easier for people to practice. as well as making it easier for female practitioners entering into the profession. And since 2021, we then brought our application, established the RSA bar, applied to the LPC to be accredited. We've been accredited to conduct pupillage training and making it easier for people to give expression to their practice of law in the preferred style and manner without being forced to quit the profession as a result. So that in a nutshell is the background giving rise to the RSA bar. Now, no organization ought to or should be based on one person's individual participation, in the sense that it would be foolhardy to establish any organization, political or otherwise, that's based on an individual, because tomorrow I die. And one would want to have an organization, and I want to believe the organization that we have is one where there will be continuity. And that continuity is, I suppose, what every organization requires. So whilst your concern, Commissioner Kane, might appear valid, I think we have made the necessary contingency plans to ensure that there will be continuity in the RSA bar. I hope that answers your question, Commissioner.
Thank you, Chief Justice.
Any other questions, colleagues? Thank you very much for making yourself available, Mr. Ford. This is the end of your interview. You're excused.
Thank you, Chief Justice.
Colleagues, would this be the appropriate time to take lunch? I'm told that it is ready, and we also missed tea, so I imagine that people are hungry. The time is 1 sharp. Would it be unfair if I asked us to shorten it to 30 minutes? Is that not enough time? It is enough? Okay. Let's come back at 25 to 2. 25 to 2.
minutes. Okay.
I just need your help one last time. Need your help.
I'll try and use my left hand.
Yes, you know I'm left-handed, right? Yeah.
Is there nothing I touch? Okay, I'll put it. Make it with a bit in the
Yeah, no.
Okay.
You go. Imagine thinking headsets could hurt me. Hey, what's up? Okay. Is it hidden, the headset?
It's hidden.
It's hidden. No, I was just checking that the headsets are hidden. Ngadlula baba, ngadlula baba. Who's the anchor? Newa? No, go for it. Oh, yes, yeah.
afternoon. Is it Miss Harvey or is it Miss Norton? Because the secretariat is a bit confused and they're confusing me along with them.
Yes, Chief Justice, it's Ms. Harvey.
It's exactly the person we want to talk to right now. Okay. Are you well, Miss Harvey?
I'm well, Chief Justice, yes, thank you.
Good.
I hope you are too.
All right, let's start with this interview of yours. You practice at the Cape Bar since 2010?
Yes.
As an advocate?
That's correct.
But before that, you had a whole other life. You started out you obtained a degree in civil engineering, worked in that field, cut your teeth in trade unionism and other interesting things, and then almost 2 decades later decided to come to this noble profession.
That's correct, Chief Justice.
All right. So you hold this BSc Civil Engineering degree, which you obtained from VETS.
That's right.
And then when you decided to join the law, you studied for an LLB and later an LLM, which you acquired both with distinction. Well, all your academic qualifications were obtained cum laude.
Well, I think the one cum laude, the other with distinction, yes.
Oh, I see. Well, what's the difference? Okay. So what kind of work did you do with the trade unions? Because I see that there may be relevant experience to be gleaned from that time.
Chief Justice, the first trade union that I worked for was SAKAU, and in SAKAU I worked for the legal unit in the WITS branch, and that was representing union members at the industrial court in Pretoria and in IMSA private arbitrations. And after SAKAU, I was then recruited by NUMSA, National Union of Metal Workers, and then I worked as a local organizer in the WITS East branch of NUMSA, organizing workers at factory level. And I did that until the 1994 elections.
All right. But that was even before you studied law? In the 80s, 90s?
Yes, that was before I studied law. I only studied law in my 40s, Chief Justice. And that was after I'd had a lot of quasi-judicial exposure through the CCMA and the bargaining councils after the 1995 LRA was enacted.
All right. So what kind of practice have you been running as an advocate?
As an advocate, it's been quite mixed. Most of my practice has been a labor law practice.
Excuse me just one moment. There's chatter that's coming from this corner that I find most disruptive. Secretariat, would you please? Yeah. Go around. I think you can go through the curtains. Okay, where were we?
I think you asked me which areas of law I practiced in at the Cape Bar, Chief Justice. It's been mainly employment law. That's been where I've received most of my briefs because it's the area that I'm best known in. And I've had the pleasure of doing some quite impactful cases in the Constitutional Court. But I've also been able to do other areas of law that's been really interesting, such as refugee law, other types of human rights law, equality court matters, and a little bit of contract and delict as well thrown into the mix. So I've had a really enjoyable and mixed practice at the Cape Bar.
But the bulk of your work is in the area of labor law?
It is, yes.
You appear in all the courts, all the way from the High Court to the Constitutional Court?
That's correct, Chief Justice.
You've appeared in the Constitutional Court, as you say, 3 times?
Yes.
In which matters?
So the first matter, I was a junior advocate in the matter of Florence versus the government, which was a matter about land restitution and the proper calculation of the monetary value of land that couldn't be restored to land claimants. And the second case was the assigned services case, which had to do with the interpretation of the amendment to the LRA to do with the rights of non-standard employees, in particular labor broker workers. And the third one was the Dunlop case, Chief Justice, which dealt with the concept of derivative misconduct.
Did things go your way?
They did, Chief Justice, yes, certainly in the two labor cases. The Florence case was not successful.
Right. You win some, you lose some. How long have you acted as a judge?
Chief Justice, I've acted for a total period of only 7 weeks. But to add to
that... In the labor court?
In the labor court, yes. To add to that, however, I do bring quasi-judicial experience spanning over 25 years. And I believe that that experience is relevant as a senior CCMA commissioner, a bargaining council commissioner, a private arbitrator, because in those proceedings, one develops many of the same skills required of a judge, including running the procedure, becoming familiar and comfortable with the rules of evidence, and engaging with legal representatives, including laypersons, especially at the CCMA. And during that time, I've issued hundreds of arbitration awards, in the process learning many of the core skills required of a judge, distilling the issues, identifying the applicable law, and writing a clearly reasoned outcome that above all shows the losing party that their case has been properly heard and appreciated. So when I stepped into my first acting stint as a labor court judge, I found myself well prepared for the role, and approximately 50 labor court cases were allocated to me over those 7 weeks, and I've handed down 26 written judgments, and I'm proud to say 5 fully reasoned ex tempore judgments, which I realized as counsel watching labor court judges is a useful skill for a labor court judge to have if she is to stay on top of her review workload. I think I came to the labor court feeling very at ease with the environment. I found it easy to settle in and to manage the procedure and to engage with counsel. And I suppose that was also helped by having practiced extensively in that court over the past 14 years as counsel. So I'm familiar with the protocols and the procedures. And I think as counsel also frequently drafting well-reasoned, clearly researched heads of argument also helps to develop the skills required for writing judgments. So the 7 weeks is not a very long time, Chief Justice, but I believe it has prepared me well, and that my track record shows that I can produce well-reasoned, properly researched judgments on time, and therefore I feel that I am ready.
Well, you preempted my question, my next question, because I was going to put to you the views expressed by, I think, at least 2 professional bodies, SAULA and the BLA, who think you could benefit from more acting time in the labor court. But you've answered, and I think you've answered fully. Maybe I should bring this to your attention as well, because I'm at that page. The BLA makes an observation that you have not demonstrated any role you may have played in the transformation agenda of the legal profession. And I look at the other things that you've listed in your CV, and I think you might have an answer for this criticism. What would you want to say to this, if anything?
Yes, thank you, Chief Justice. I did see the comment. I have contributed to transformation in a few ways, both within the bar, which I think is the focus of interest of the question, and also more broadly through my work on access to justice. Just starting with the bar, my main contribution has been to advocacy training. So that has been to attend a 5-day residential course to qualify as an advocacy trainer, and then spending many hours as a member of faculty training pupils who are selected in line with the Cape Bar's transformation agenda. And the training that is given to pupils includes intensive one-on-one coaching to help them to develop their oral advocacy skills, and also feedback on their written advocacy skills, such as pleadings and heads of argument. I've also contributed to Cape Bar committees. In the early years, I sat on the mediation committee. I've also sat on the council and on various disciplinary subcommittees, and at the moment, I'm a member of the fee dispute committee of the Cape Bar. And when it comes to briefing patterns, Chief Justice, because I know that this commission is interested in that, I am a junior myself and I have never been briefed with a junior. And aside from recommending excellent black female counsel to attorneys, I haven't been in a position to influence briefing patterns. But I have always been keen to mentor juniors who are interested in labor law. I have found that it isn't the most sought after area of law that young advocates want to get involved in, but where they have shown interest, I've, in two matters, I have split both the work and the oral argument with those juniors so that they would get real substantive experience, and in those cases I've also split my fees. But Chief Justice, as you alluded to, my main contribution to transformation has been through my work on access to justice. And that is because I feel that if we are to transform the profession, we need to do more than improve access to work. We also need to improve access to be heard. And that's because if there are groups who are routinely not heard by our courts or are excluded for one reason or another, then our courts will not be in a position to develop the common law in the way that the Constitution wants courts to do. So, since I've been at the Cape Bar, my main work in support of access to justice has been firstly in pro bono hours spent on impactful cases, such as the Uber case and the case amending Rule 25 of the CCMA rules to permit broader representation. And then allied to that, trying to build capacity in the main legal NGOs, LHR, LRC, and in community advice offices, so that legal representation is more broadly available to the community at large. And in that respect, that kind of segues into a special interest that I have in the issue of language, Chief Justice, because I believe that access to justice also means that a person needs to be properly and fully heard in court, but perhaps I should address that later. I think my answer has been pretty long as it is.
All right. You don't have any reserved judgments, do you?
I do not, Chief Justice.
All right. But I would have liked to hear a little bit about your ability to speak African languages, but if you want to defer it, we're in your hands.
It's really about the intersection between language and power. It's something that's interested me. When I left school, I lived in Botswana for a year in order to learn how to speak Setswana. And I experienced firsthand how deeply disempowering it was not to be able to express myself eloquently in the language that was being spoken around me. I felt that I was sort of lost in translation. I couldn't really show up as my full self because I couldn't express everything that I wanted to say. In fact, I felt almost childlike. And that made me very acutely aware from then on, and I was only 17 years old at the time, of how much language and power intersected in South Africa, and how language could be a barrier to accessing justice and to accessing institutions. It obviously helped me in the trade union movement, Chief Justice, but when I got to the CCMA, I quite frequently noticed that weak interpretation undermined a person's right to be heard. And of course, that links back to my first point, which is that if courts cannot hear fully and properly the full nature of all South Africans' experience and perspectives, then it's not just the litigants who are deprived of a fair hearing, but it's the courts themselves that are deprived of an opportunity to develop the common law in the image of everyone in our country. So I'm very passionate about language as an issue. I know there's various things that can and can't be done about it, but that is what I wanted to say about language, Chief Justice. Thank you.
All right, thank you. Judge President Mlahle.
Thank you, Chief Justice. Good afternoon, Ms. Harvey.
Afternoon, Judge President.
How are you?
I'm managing.
I should be say Dumela.
Dumela.
O tsogile.
Ke tsogile.
Ke a leboga. I see your practice is about 85% labor, and you do other things which we'll talk to later on. But before we go in there, let's talk about the most important thing. If you are successful, I see you've applied for both Cape Town and Johannesburg. That's going to be easy for you to relocate because I see you are resident in the Cape.
Yes, thank you, Judge President. I was born in Johannesburg. I grew up in Joburg. I spent more than half my life there. And I'm fully prepared to return to Johannesburg if that's where you, as Judge President, would like to deploy me. That is not going to be a problem for me. I feel very comfortable in Joburg, and in fact, it is my home.
Okay.
So, yes.
It's quite important because I've seen over my period serving in the labor courthouse, this traveling and relocation can be frustrating for individuals because it's not only you, it's the family and everybody around you.
Yes, Judge President. One of the reasons that I'm so prepared to relocate at this point is that both of my children are grown. They do live in Cape Town, but I'm really free to move as I please. Okay. And when I went back to university to study for my law degree in my mid-40s, it was precisely because I had the aspiration to attain the experience and the qualifications to become a judge. Okay. And so a judicial appointment is more important to me than the location.
Okay, and you realize that you have actually traveled between Cape and Johannesburg. I think you did Cape Town and Durban. You've done the 3 courts.
Yes, Judge President.
And you have no problem with it?
I have no problem with that, Judge President. In fact, I love traveling from court to court. The CCMA also used to send us around the country.
Yes.
And I find that the quality and the types of disputes are different in different areas. Yes. And it really adds to the variety of the work.
And the traveling is likely to increase because with the limited number of judges we have, we may require you to go to Limpopo, we may require you to go to Mpumalanga, and next to that it's likely to be Northwest and the George area.
I would really welcome that, Judge President.
Okay. And talking about the George area being from the Cape, what is your view about the court being only in Cape Town city itself? And have you experienced people not being able to access the court simply because they have to travel long distances?
I haven't experienced that personally, Judge President, but it's obvious that the fewer seats of the Labour Court that we have and the fewer seats of the CCMA and the bargaining councils, the more difficult it will be, especially for vulnerable persons to access.
Okay. And have you looked at the manual for acting judges?
I had the manual sent to me, but only after my last acting stint.
Oh,
Judge
really?
President.
I'm sorry to hear that. But have you had a chance to look at it?
I have, Judge President, and I understand that there's a concern about tea room attendance, if I may preempt your question.
Yes.
The main answer to that question, Judge President, is I went to the tea room once or twice during the week that I acted in Johannesburg, but on both occasions nobody else was there. And I think that's because there was a shortage of courts during that week. And on most days, I had to wait for another judge to finish in a court before I and my parties could then take over that court and deal with the cases. So I wasn't on a usual court schedule. I think I was probably starting at about 11 or 12 and just working straight through. When I saw the manual, I then realized that tea room attendance is valued in Johannesburg. And I would greatly value that. I do
Okay.
think that that sort of informal collegiality between the colleagues is important and necessary. And if I'm given the opportunity to act again, I will definitely
Yes.
go to
It's
the
in,
tea room.
it's in fact not only Johannesburg, it's all the courts. Even though Cape Town you would have 2 judges, the same with Durban, and 1 judge in Gqeberha. And I have noticed when I visited some of these courts that judges where there are only 2, they don't attend tea. Whereas when I was in Gqeberha, 2 cases arose where we needed another judge to step in. And that's one of the values of attending tea, that for me, either as a JP or the senior judge would be able to say, yes, here you are, could you come to tea? I won't take point with you being in tea alone, but that week I was in Johannesburg and attended every single tea. And I saw you on the Friday as you were leaving. That's when I was walking to tea. But I'm not going to argue your point that you were in there alone. Sometimes judges come late and whatever, but it is important.
I take the point, JP.
Thank you. I see you appear also in a range of matters, and I think you've already made the point in answering to the Chief Justice question. You've dealt with derivative matters, you've dealt with dispute in between in labor brokers, constitutional equality case in the education sector, and you list a whole long list of cases that you've attended to or dealt with. Now, your acting stint, also you've touched on that. From my record, you acted between July and August 2024, and you acted pro bono 1 week, and another 1 week pro bono. And I must thank you for that, because we called you at a very short list time to say we were faced with a challenge. Could you come in? Your total acting stint is about 30 days from my side. And in your acting stint, did you do urgent cases?
Yes, JP.
And did you do them through court online or still the old system?
It was still the old system.
So you're not yet trained in the court online system?
I'm not.
Okay. And in terms of the virtual hearing, we've just dealt with the issue of access and trying to make sure by other means people will have access to court. Have you used the virtual court system?
Judge President, in my first acting stint, I think that was in 2021, it was during COVID, and we did all the cases online at that time. I think that's a different system to the one that we use now. I haven't done any virtual hearings in my last acting stint, JP, but obviously I've appeared in virtual hearings as counsel. Yes. So I'm familiar with the process from that side of the table, as it were.
And what is your view about the usage of virtual hearing, particularly in relation to access to justice? Some people have argued that it actually limits the access to justice.
That's a difficult one. Obviously, it improves access where people can't travel, but limits it where people don't have access to data or the technological interface. I had a matter, I think it was a pre-trial conference in the Cape Town court, where I think the attorneys were in Johannesburg and the applicant was in Cape Town, and they wanted to do the pre-trial conference. It was a judge-chaired pre-trial. They wanted to do it on the virtual platform, and we managed to get the applicant to come into the court, and the registrar set the applicant up with a screen. So I suppose if the Labour Court were to spread itself throughout more centres, and then were to make virtual access available to litigants in those centres by providing the technology and the data and the interface, then I suppose it would improve access to some extent, although I personally don't prefer the virtual platform. I prefer the in-person.
But don't you think it would also help with the point you've just raised about judges having to wait for another judge to complain, which I must tell you personally, it frustrates me. I feel very offended having to wait for the court. And it actually causes tensions between the judges, because one judge will say, I'll be finished by tea time. And we know how cases unravel. By 1 o'clock it's not done, and you're still waiting. Isn't that also another way of addressing that particular problem that we're having in the labor court?
Yes, I take that point, Judge President. I personally didn't feel offended, but I suppose that's because I was just a junior and an acting judge, and so I expected to come later. But
Okay.
I understand your point, and I think it's a valid one.
And if I take into account, yes, I do hear you when you say that you have a an extended period of involvement in labor matters. You do appear quite frequently in labor matters, and your practice centers around labor in essence, and you've got a long history of it. But what would you say if I was to say, looking at your period of acting, it seems to me we may need to offer you, if you're not successful, a further acting stint. What would your attitude be?
Of course, if I'm not successful, Judge President, I would very much welcome the opportunity to do further acting stints.
Okay. Thank you very much, Chief Justice.
Thank you, Judge President. Colleagues from NETLAC, do you have questions? None. Right. Minister?
Thank you very much. Let me start to where some of the questions were asked. And start, good afternoon, Advocate Harvey.
Good afternoon, Commissioner.
On your response or your questionnaire, you've got Golden Arrow Bus Service versus another and versus and the Minister of Employment and Labor. And you've listed this case as a reportable case. Is it an error of judgment?
I'm not quite sure if I understand the question.
It is definitely not reportable, but you've listed it as reportable. So I'm asking whether it was an error or you were cognizant, or what could be the reason that it was.
Is that in the list of cases where I've appeared as counsel?
Move the mic closer to you.
Is that in the list of cases where I've appeared as counsel? It's certainly not a judgment that I've issued. I'm just
trying to understand your response.
Maybe you could take me to the page in the bundle which you're referring to, because I'm not understanding the question.
Okay, on page 20.
Yes.
If you look at them, because they are saying, give us reported judgments that would have been part of, and you are saying as per an advocate. But I'm saying the first one that you have listed there, you've listed as reported, but it's not.
So these are cases, or these are judgments in which I appeared as counsel, and that Golden Arrow bus service case is reported because the citation is there. It's been reported at 44 ILJ 1715. So these are cases that I have found in the law reports in which I've appeared as counsel, and it's definitely a reported case, Commissioner.
Okay, because I've looked at it, I found it not to be. But let's move on. The issue, because one of the issues that you're making reference to, and I think one would have to, while I acknowledge your commitment and explanation, as CJ was asking you about the time you've spent acting and the expectations thereof, and your explanation. And I must say, this, as a person who does the work, I'm inspired by you, because as much as my work takes me everywhere, I would love traveling and not have a problem with it, leaving my family, my partner. It's such an inconvenience to be able to do, because one day I'm expected to be in Limpopo, in Mpumalanga, and come back. It just destabilizes your life. and your health never gets to be a bit organized. So that's what I'm saying. From your comments, I think I'm a bit inspired to hear that you don't mind that at all, and you don't find it as an inconvenience. Let me come to the issue around what do you think that efforts that are necessary for us to be able to transform our judiciary, and it's also linked to what the question was asked by the President in terms of utilization of virtual platforms as part of access to justice, but where the courts are located and the people that are meant to be served. What do you think should improve in that regard?
Commissioner, the question of access to justice, I think, is almost a crisis in our country at the moment. And there are a number of different ways that it needs to be addressed. One issue is that employees and ordinary citizens are, to a large extent, unrepresented. Union membership has dropped, I believe, below about 20%. And there are many, many employees. We're talking about employees here because they're people who will be wanting to access labor law justice, who don't have any access to any form of representation. So I think that expanding forms of representation is one of the ways that one would improve access to justice. Expanding the seats of the Labour Court, as the JP raised with me, I think that will assist, as well as the virtual platforms if the resources are supplied. And then, yes, I do think that a transformed judiciary, or a judiciary which is able to hear people in their own languages, is important. I know this is possibly a controversial policy question, and I understand that English is the main language of the courts. But of course, if somebody hasn't had proper interpretation in a lower tribunal, and the record on review or on appeal is only in English and goes up to the next level of tribunal, then whatever shortcomings the original interpretation had, then just carry on going up through the system. And so I think that a lot of attention could be paid to professionalizing, either to running processes in South African languages and not only in English, or to putting a lot of attention into professionalizing interpretation in employment law matters.
Professor Murumachai?
Thank you very much, CJ. Good afternoon, Advocate Harvey.
Good afternoon, Commissioner.
I have two questions for you. One is more substantive, and the other one, it is just out of curiosity. Let me start with the more substantive one. In your questionnaire, in the paginated page 23, there is a judgment that you, and I must commend you for that judgment, because my understanding, you'll correct me if I'm wrong, is that it's not necessarily easy not necessarily to prove constructive dismissal cases, but to win them. Because of this concept, they are not inherently unfair, which I've never understood. And this judgment was delivered in the height of COVID, in circumstances where, in this case, an employee was forced to take a salary cut of 25%. And generally around that time, you found that most employees, or some employees, were laid off somewhere. We said, look, can you please go home? We cannot do anything. You can come back after whatever time. So even though there were companies that were genuinely going through difficult challenges, there were those who were taking chances. And I think this is what you were kind of like dealing with here, because there was no evidence of a company not actually doing well. In fact, in the previous year, they did well. And that's why this actually was able to pass. The question that I have for you is, when one looks at the jurisprudence of constructive dismissal in South Africa, and the test that is provided for in Section 186, subsection 1E of the Labour Relations Act, can employees adequately rely on the remedy of constructive dismissal in South Africa, or is this just a toothless remedy that we have in this country?
It is a difficult area of law because, of course, an employee who resigns and then claims a constructive dismissal takes a big risk that they're not going to be found to have been dismissed. So I wouldn't call it a toothless remedy. It's certainly one of the more difficult remedies to access. And I think that's why I found this case so interesting, because for a long time I had also struggled with the concept of, if you were put in a position where you resigned because of intolerability, why wouldn't it necessarily follow that that was unfair? And I understood that perhaps you could be put in an intolerable position, but that the employer was as fair as it could be when it put you in that position. So it was always difficult for me, actually, when I was before I got to this judgment, to really draw out those two strands. And I think that when I really had to sit and analyze this situation, I realized that objective intolerability went to the employee's experience, and that unfairness went to the employer's response, so that an employer could respond fairly, in theory, to an employee's objectively intolerable circumstance, or an employer could respond unfairly to that circumstance. And I hope that that judgment made it easier. It certainly made it easier for me to think it through subsequent to that. I hope that it would make it easier then to do the analysis, to look firstly at the experience of the employee, and then to look fairly at the response of the employer, and to separate the test out like that.
Yeah. No, well, the facts allowed you to do that.
Yes.
My second question, or the second question that I have for you is, when the CJ was leading you on the question of transformation, I'm not going to take you to task with transformation. You said something that really made me kind of like be interested. When you said that there are times where you recommend excellent black females. And I just want to ask you, because we often hear this word, something being put next to either black females or black men, when you are dealing with the issue of merit in South Africa. Like, for instance, you never hear excellent white female or excellent white male. Like, was it necessary to say excellent black female? I mean, what motivates that?
I would like to think that people who think highly of my work would say that I'm an excellent white counsel. One wouldn't recommend somebody who's not excellent. I think that is why I used that descriptor. But I take your point, that it is possibly an implied, an implication in that phrase that makes it sound as though most black female counsel are not excellent. I take your point.
Thank you. Thank you, CJ.
Commissioner Mangen.
Thank you, Chief Justice. Good afternoon, Advocate Harvey.
Good afternoon, Commissioner.
Yes. I also want to canvass a point with you on this case of Wesco, where you dealt with constructive dismissal. But I want to talk to you about the remedy for constructive dismissal. The commissioner had actually awarded compensation of 6 months, having found that the dismissal did take place due to intolerable working conditions. Now, what I want to establish from you is, are there instances where, arising out of a constructive dismissal, reinstatement can be a competent remedy?
Yes, thank you. It's an unusual remedy because usually the relationship is found to be intolerable by the employee. But I do think there are circumstances when a person could be reinstated. I think once or twice I've come across circumstances in my role as counsel where intolerability was, for instance, caused by bullying or harassing behavior by some superior, and that if that person either left or was moved into a different department, then the employee would be able to return to work. And it always depends on what the employee wants, what they ask for in the CCMA. If they ask to be reinstated, then reinstatement needs to be seriously considered. So no, I don't believe that reinstatement is completely out of the question. In a constructive dismissal, I don't think I've seen a case where a constructively dismissed person was reinstated.
Now, if I can just follow up slightly on this aspect. In the context of this case, as I understand it, the issue was arising out of a salary card, really, which impacted on the wellness of the employee and leading to financial distress because the family was suffering because he was working reduced hours. And then he resigned as a result of that salary cut. Isn't it an instance where once the financial position of the company improves and COVID had passed, and that there was no need for then the company to experience financial difficulties, the employee can actually be able to go back into his or her position?
Yes, on the facts, Commissioner, I'm sure that would have been possible, but that wasn't the claim.
Thank you, CJ.
All right. Commissioner Chairperson.
Thank you, CJ. Good afternoon, Advocate.
Good afternoon.
My question is actually probed by the statement made by Professor Marumahai when he asked you the first question. Based on what he said, I just want to ask you, how would you balance the constitutional right for fair labor practice vis-a-vis the economic realities facing businesses, especially in this struggling economy?
So I think that the question is about fairness. We're talking about fair labor practices. And when one considers fairness, one's looking at the conduct of an employer and whether it respects the dignity and the personhood of the employee. We don't live in a fair or an equal society, and so the right to fair labor practices doesn't fix all of that. So one looks at the tests for fairness, and one weighs up the conduct of the employer and evaluates whether it's been fair or not. And as was said in Sidumo, when it comes to a CCMA commissioner, that depends on, it's a value judgment, and that depends on the sense of fairness of the commissioner or, in other cases, of the judge. I'm not sure if that answers your question, Commissioner.
President Moleme. Have you finished, Commissioner Hampton? I'm so sorry. Okay.
Thank you, CJ. But then the statement that he made, it has got nothing to the right or wrongdoing of the employee. But in the main, it's a situation that might have been created by the economies of scale at the time. So here's the person who's earning so much, and willy-nilly or for whatever reason, his salary has been reduced by 25%. And in my assumption, I would assume due to economy or the financial collapse of that particular company. Now, where do you draw the balance between the two?
Yes, absolutely. That does go to the facts of this matter. Absolutely, if the company had been able to show, and if the company had claimed that it was in genuine financial distress, then it may well have been that the conduct of the company, although intolerable to the employee, was nevertheless fair. And that is the inquiry that I undertook in the second phase of my reasoning. And on the facts, the employee had approached the company, had said that she couldn't afford to take the cut, and had given the company an opportunity to explain its finances to her. And the employee had also, if I could recall correctly, and it is in the judgment, the employee had brought to the company's attention its good financial performance in the previous year, which this employee happened to know about given her position. And I took all of those aspects into consideration, Commissioner. And I think the implication of that certainly is that if the company had been in genuine financial distress, then the interests of fairness would have supported a finding that although it was intolerable to the employee, it was nevertheless a fair, constructive dismissal.
No, thank you very much, Suchi. President Mulemel.
Thank you, CJ. Good afternoon, Advocate Harvey.
Good afternoon.
I'm over here.
Could you wave?
Right
Thank
here.
you, thank you.
Yes, you referred to the well-known case of judgment of Sidumo, and I think other candidates have done the same. One thing remarkable about that case is that I think if it doesn't hold the record, it's one of those. But I mean, it was in the courts for more than 20 years, between the date of dismissal and the date of finalization by the Constitutional Court. Now, Sidumo happened long before the era of CON-ARB. And one of the reasons why CON-ARB was introduced was try to expedite the process. Now, the previous candidate indicated that there's one matter that he was involved in where the employee in question was dismissed in 2019 and the matter has still not been finalized. Two questions that I'm posing to you is, what is your experience in as far as the finalization of matters is concerned? Do we have lots of those where by the time you hear the review, the employee was dismissed more than 5 years ago, for example? And would you say that CON-ARB has been beneficial, has served the purpose it was intended to? Thank you.
Thank you, President. Yes, I have seen a lot of cases where, despite all efforts to the contrary and all pronouncements to the contrary in the LRA and every other piece of employment legislation, labor disputes are not timeously and expeditiously resolved. And yes, where dismissals took place 5 and more years ago, and they're coming before you as a labor court judge, and you're just unarchiving it or something, and you know that it's now going to take another year before the merits are actually heard. So I do think there's a crisis with delays, and that the system is not working the way that we hoped it would work when the Act was passed in 1995. CON-ARB doesn't seem to have worked. That section provides that basically every case should be set down for CON-ARB. I think unless it's probation or something, there's a very small group of cases that wouldn't automatically be set down for CON-ARB. But I find that employers routinely object to CON-ARB, and all that has to happen is that a letter has to be sent in, and automatically the two processes are separated. And in the early years, in the early 2000s, that didn't really matter that much because arbitrations were being routinely finalized within 60 days. And I think the wait for a labor court review was under a year. But now, I believe because of capacity issues in the CCMA and the restricted allocation of work to commissioners, the time taken from between conciliation and arbitration is now very much longer. And the time for review in the labor courts has also become much longer. And add to that the increasing legalism of the review process. I think all of those things have contributed to delays, such that, such that there really isn't a meaningful expedition in resolving labor disputes, as I believe was intended.
that being the case, what would be your proposed solution? I mean, there's no right or wrong answer, but in your opinion, what would be the right direction for us to go into?
Yes, a number of things would have to be present. Firstly, there would have to be fewer disputes, and that would be achieved by having a stronger labor movement. Where you have a strong labor movement, disputes are more often resolved at workplace level, and you don't find many, many hundreds of individual employees each inching their way through the statutory procedures. So a strong labor movement, a stronger CCMA with good interpretation, and people who, like I believe the cohort of 1995, 1996 commissioners we were all people who were pulled from a very fractious labor environment at that time. And we were all very clear about how important resolving labor disputes was. And there was a big emphasis, not just on sort of technical conciliation, where you say, would you like to settle? No, you wouldn't like to settle. Here's your certificate. That is what we had experienced under what was then the Department of Manpower conciliation boards. They would just almost certificate your case to go forward. When we first started with the LRA, there was a meaningful attempt to conciliate and to really intervene in the relationship and to really ensure that both sides understood that the CCMA would enforce the rights that were provided for in the LRA, both in favor of employers and employees. So, a strong union movement, better quality of conciliation, and then I suppose resources. One needs more commissioners, one needs more space, one needs more courts, I suppose, in the labor court, but that is a question of public financing. So, many of these things are beyond one's control, but I think all of those would help.
Thank you very much, Advocate Harvey. Thanks, CJ.
Commissioner Moimang?
Thank you, Chief Justice. Good afternoon, Advocate Pile, this side.
Good afternoon.
Just one from my side. Can you share with us your appreciation of transformative justice and how will you use how can the labor court be used to advance transformative justice? I'm raising this point because one of the comments made by GCB appreciated the fact that you have devoted your career to utilizing law, particularly labor law, as a means to achieving social justice. If you could also just share on that point. Thank you, Chief Justice.
So thank you, Commissioner. If I've understood the question, transformative justice goes beyond just adjudicating who's right and who's wrong. It goes to restoring relations between people and affirming people's dignity and sense of agency in their own lives. And a justice system that is working properly will achieve that. I'm not sure if that answers your question fully enough, but if I've understood it correctly, that would be my answer.
Yes, look, I think your background, I suspect you will appreciate that law, like many disciplines, is part and parcel of the superstructure and is informed by the base. So obviously, in the South African context, there's a lot that is expected of all of us, three arms, to ensure that the rights as enshrined in our constitution, particularly your referral to Labor Relations Act, is used to address the historical past. So I expect you to share more. How do you use the bench to be able to ensure that the vulnerable and the marginalized get the necessary justice? Thank you.
the past when people were divided, we were divided along racial lines, but along work lines as well. And so working class people were in the main black, not English speaking, and without access to power. And the Constitution aims to redress that, but we still sit here many years later with a lot of inequality in our country. And I'm not sure what to say to that. Law can transform society, but only to a certain extent. And legal rules, yes, they can only be used to a certain extent in transforming society.
Thank you, Advocate. Thank you, Chief Justice.
Chief Justice, could I just follow up on this question?
Yes, Commissioner.
Thank you, Chief Justice. I suppose, Advocate Harvey, this point about law at the crossroad of transformation, as posed to you, goes back to your history. I think that's what the Commissioner is saying, that you've been at the forefront of using law as an instrument of justice in your work, for instance, for employees, so-called employees of labor brokers, in your work on behalf of farm workers, or both of those being extremely vulnerable groups that are super exploited. Even though your answer is an exasperated one about the limits of the law, but there is also a potential of the law, and it can be exemplified in what struggles have been engaged inside the courtroom and what have been the successes of those struggles. I mean, I think if we all shrugged our shoulders, then we must close this commission. But the reason we are here is because we think that there is scope for using the law to transform society. The question is, how will that happen? How have you done it in the past? Because the Commissioner is asking about your background. And what are you planning to do about it now that you're going to be a judge?
I think that goes back to that question of access to justice. The law can only be used to transform society if people have access to it. And I think I've spoken to that, and that has to do with issues of representation, issues of social power, issues of language. When it comes to being a judge, one of course sits in a completely different position. As an activist, as a trade unionist, as a citizen, and as an advocate, it has been possible to take on social impact cases that might not otherwise have been heard, that contribute to building the law and to modifying the common law. One steps into a very different position as a judge. As a judge, one shows up not as oneself, but as a functionary within the system, and one then sits as a representative of the overall legal system itself, and the system of precedent and the system of legal rules becomes very important. And that is important to appreciate, because without a commitment to the rule of law, the entire system won't work. So I think there's a big difference between being an advocate for transformative justice and being a judge who, in the greater scheme of things, is upholding the rule of law in the bigger system itself, so that it can function correctly and so that law can be knowable and certain and consistent for everybody who approaches the courts.
Are you saying that judges cannot be advocates of transformative justice?
They're not advocates of transformative justice beyond what is mandated by the Constitution and by the statutes that they wield.
Thank you, Chief Justice.
Thank you, Chief Justice. Good afternoon, Advocate Harvey.
Good afternoon.
I'm finding your answer particularly difficult in the context where the court you're applying for is the Labour Court, which is really the epicenter of transformative justice. And perhaps you'd want to just explain that again.
I am having difficulty with this question, Commissioner. Yeah, I really...
Chief Justice, could I
really
maybe also
sorry.
assist Commissioner Hassan? Sorry, I know it's difficult to find everybody.
Yes.
Maybe just to build on Commissioner Pilay's question. What we're trying to understand is whether you believe that the courtroom is a terrain or a space of struggle, or a space to actively, as an activist, fight for, whether it's restorative justice, you want to use those semantics, or whether we want to talk about systemic change, etc. So we're trying to understand whether you believe, maybe in some ways on an ideological level, whether the court is a terrain in which you can advocate that kind of activism that we know you fought for access for justice for, we know you're a trade unionist, etc., etc. So we just want to understand how that experience can imprint in your work potentially as a judge. Thank you.
Quickest, CJ? CJ? Just a quickest addition. Are you a transformative agent?
Am I a transformative agent?
Are you an agent of transformation, put differently?
Yes, I would like to believe that I am, especially as an advocate who has taken cases that I believe are important and have had social impact, and I have framed legal arguments and come up with legal innovations that I believe have had the potential to transform in certain instances. I certainly don't believe that law is everything. I think transformation in society goes far beyond the law, but to the extent that it can be used to transform, I think that the Constitution and the LRA give us a very rich framework to do it in. But as I've been trying to point out, when one is a judge, one is no longer an advocate, one isn't bringing one's own cases to court, and one is constrained by the legal rules and by the rules of precedent. So I do see the two roles as distinct and different.
Has your question been addressed, Commissioner Pillay?
No, not really, but I have a second part to the question.
Carry on.
Advocate Harvey, I was interested in your answers to the Chief Justice on your contribution to the transformation of the profession. Now, did I understand you correctly that you've never been briefed with a junior?
Yes.
In any of your matters?
Yes.
I was going back into your CV and I see that you say you appear frequently in the Labour Court, in the Labour Appeal Court, in the High Court. You've got multiple appearances in the Constitutional Court. And you're saying in none of those matters were you briefed with a junior?
I was never briefed with a junior, Commissioner, no.
And have you ever requested to be briefed with a junior?
I haven't, Commissioner. Generally in most of my cases, especially the high-profile cases, I've been alone, and in many of those cases, I'm opposing quite formidable teams of silks on the other side, appointed by large and powerful law firms and large and powerful employers.
I accept that, but did you request a junior to be brought on to assist you?
But I have not requested a junior.
You've never seen the need to ask for a junior on any of your matters?
No, Commissioner. I'm fairly junior myself, remember. I've only been at the bar. I'm in my 14th, I think my 15th year now, or it's the 14th year. I've never requested a junior, and I'm not usually briefed by the sorts of clients who would be able to afford a second advocate working on a matter.
You see, Advocate Harvey, I understood you as saying that part of your contribution to access to justice is that you act for entities like Lawyers for Human Rights, the LRC, etc.
Yes.
That's your contribution to access to justice. And so in working for the LRC, LHR, etc., You've never asked to be briefed with a junior.
No, I haven't.
Thank you, Chief Justice. No questions.
Just to clarify on that, that work also has been pro bono work. So it wouldn't be a case of asking to be briefed with a junior. It would be a case of accepting to do the work pro bono myself.
Sorry, just a last follow-up, and I'm sorry about this. In your application, you go to great lengths to say that you recognize the importance of a source of work for youngsters. You put quite strong language, you set it out in strong language in your application. The importance of having access to work for people's dignity, etc. And so I must put to you, I have a fundamental difficulty with understanding how, once you place emphasis on that in your application, you also place emphasis on the fact that you appear regularly in our highest courts, but you've never been briefed with a junior and you've never asked for a junior. The two, for me, are completely irreconcilable.
If I could just separate them out for you, Commissioner. When I mention work in that context, I remember the section that you're referring to. What I'm saying is that labor law, it's part of why I find labor law compelling and interesting. Some people think that it's just a very narrow area of law and that it's not particularly fun or interesting. But I find it a very important area of law because it intersects with a person's dignity in the sense that one's identity is tied up in the work that one does. And so when one is in trouble with one's employer or with one's job, that affects one's identity, one's role as a breadwinner, one's role as a family person or a parent. So that is, when I mention that, it's from the point of view of trying to interest other lawyers in labor law. And when I've given training, I remember I gave training at Tulamela Chambers some years back to try and interest young advocates in taking on pro bono cases. And I started with a slide that said, labor law is human rights law, because you find that a lot of people are interested in human rights law, but they don't realize that labor law is human rights law. So in my application, Commissioner, when I speak about work being an important source of identity and dignity, it's in that context that I'm explaining why labor law is a particularly rich branch of law to work in.
So when you say recognizing that work is an important source of human dignity, self-worth, and sense of value within family and community,
yes,
you don't mean that juniors around you would need work in order to have those sort of comforts, a sense of dignity, a sense of self-worth, etc. And that as a senior in that space, you've got a responsibility to ensure that you firstly transfer skills, but secondly also bring juniors onto matters so they have a source of work.
That isn't what I was writing about in that section, Commissioner, but I acknowledge what you're saying and I agree with it. But I do repeat, I suppose, for about maybe too often, that I have not had the opportunity to be briefed with a junior. I haven't been in a position to ask a client to brief a junior because in those matters, clients have only been able to afford one advocate.
Follow up, CJ.
Where's the camp? Oh, yes, Prof.
Advocate Harvey, I'm having serious difficulty in understanding you, and perhaps maybe just for my understanding, if you can just assist me. On the one hand, you are saying that you are an advocate of all the values that you have been speaking about, right? On the other hand, you are speaking about you doing pro bono matters. And on the same breath, you are talking about payment. My understanding about pro bono is there's no payment. Am I wrong?
That is correct.
Yes. So you are doing a public interest matter. You have been briefed by a public interest institution to do a matter that will potentially be reported. There's no issue of affordability there. Perhaps maybe if you win, whatever institution can say, whatever cost they can be paid to you, as is normally the case. So under that context, you have not seen a need of saying, can I bring a fellow person who can actually benefit from this process? That's how I understand this transformative argument from a constitutional point of view coming from. That, if you can just clarify me on that, because I'm very confused of what you're saying.
Yes,
Sorry,
Commissioner.
before you answer, just to expand on that issue. You did ask me to lead you in the Constitutional Court once, didn't you?
Yes, Commissioner.
All right, so then maybe, I don't know if that is transformation or not, but at least maybe it's something that helps you.
Are we
Feel free to
answering
mention.
questions for candidates now, Commissioner Ngqaito? I have a strong feeling that that candidate is well able to speak for herself. So let's please let her answer for herself.
I withdraw that, Chief Justice.
And of course, in that matter, Commissioner Ngqaito, I was your junior, not the other way around. Commissioner, yes, maybe what I haven't made clear enough is that I have been very interested in encouraging young advocates to be interested in labor law. There aren't a lot of young advocates at the Cape Bar who are interested in labor law. If there had been, they would have definitely been brought on board. It's not as if there are lots and lots of junior advocates who are just dying to do pro bono cases. It's been incredibly difficult to find counsel for cases, and a number of cases have been offered to me about very important issues that I would have loved to have taken up myself, and counsel has not been found to take on those cases pro bono. So if it is your impression that there are lines of people waiting to take on these very important and socially impactful pro bono cases, I'm afraid you're mistaken. That's not the situation that we're in at the moment in the legal profession.
Commissioner Nkonyan?
Yeah, thank you, Chief Justice. Good afternoon, Advocate Harvey.
Good afternoon, Commissioner.
I was going to ask this question as the second one, but because of the line of question before me and your response, I feel I must ask it now. I noticed that you have been recommended by about 5 senior counsel. Are you in a position to tell us on what basis? Did you work with them, that type of thing?
They're all senior counsel that I've worked against, actually. I might look at the list again now and just think about it, but they are people who were familiar with my work because I had appeared in the same matters with them, but on the other side.
So they were your opponents?
Yes.
Okay. Anyway, the question I wanted to ask you first is what I see as a missing link in your career path. Perhaps you will clarify. I noticed then that in 1991 until 1994, you were with VETS East NUMSA.
NUMSA, yes.
Yes, but thereafter, you then went and worked as a full-time commissioner of the CCMA in 1996. That period after you left NUMSA and the period when you assume your responsibility, I see a missing link there. Where were you and what were you doing?
My first child was born in 1994, Commissioner, and I was at home looking after her. At some point during that period, I trained with IMSA as a mediator, and then I was invited to take up a position at the CCMA in 1996.
Thank you, Chief Justice.
Commissioner Hassan, your hand was up at some stage. Did the follow-up question cover you? All right. Commissioner Matolo Dlebo?
Thank you, Chief Justice. Advocate Harvey, I think I was, whilst we were answering questions from Advocate Pillay, I was a bit worried that do you really understand what transformation is all about and skills transfer? And moreover, that you can't even, I just need to understand how do you reach out to young black advocates? Because I see in your documents you seem to have said a lot about transformation. I just want to understand the link, how you do it, because from what you are telling us, I'm not sure I hear you properly.
You want to know how I reach out, Commissioner?
Yeah.
By engaging with advocates at the bar. There's a very small group of advocates at the Cape Bar who do labour work. I'm always excited when I see somebody come along who wants to do labour work because it gives me somebody to talk to and somebody to work with. So that's how I reach out, is by having relations with those counsel, by dropping into their chambers, asking them questions. They come into mine and ask me for help with their cases. So that is how I interact with other counsel who are interested in labour law. I don't have an attractive practice in commercial law, other types of law that many young counsel are interested in, and so I'm not in demand, as it were, for that kind of work. And that is why I've put my effort more into advocacy training, and I have made the point earlier in this interview that I feel that transformation goes beyond access to work into the question of access to justice. That is my answer to that. So
sorry.
Yes.
Have you finished now?
Yes, thank you.
All right. Commissioner Matulaship.
CJ, I'll leave it there.
Okay. Commissioner Matthews?
Thank you, CJ. I just a quick question. I understand that, like in this discussion with other commissioners, particularly regarding black involvement with black counsel, the role of an advocate, I know you are not choosing who the client must be and who must be, but what do you think the advocates, particularly senior advocates or senior junior, would play in advancing transformation in the area of briefing? How would you encourage, what do you think should be done in that area, or what would you advise?
It's a difficult question because, as you yourself point out, as advocates, we don't influence briefing patterns. And as a junior female counsel myself, I've found that I haven't always had access to the kind of work that I might have wanted. So I'm not sure how one addresses that, other than possibly having the judiciary itself do more to encourage legal teams to be more representative and to encourage senior advocates to allocate substantive portions of the work to juniors rather than simply having them on board in name only. And that is why on those two occasions when I have found juniors who really were interested in labour law, and in fact in one of those occasions I did ask the client whether we could bring one of them on as a junior, but the client said no. That is why when I've had those juniors interested in cases that I've been doing, I've given them a substantive portion of the work, including the drafting and also the presentation of argument in court. And on those two occasions I've shared my fees with them because they needed, their contribution had to be recognized and properly valued.
Okay. Thank you.
Anyone else, colleagues? Commissioner Kane?
One short question, if I may. Good afternoon. Assuming you are not recommended at this stage by this commission, it is the stage in your career at the bar where one would ordinarily apply for silk. Are you intending to apply for silk?
I think that I probably have another year or two before I'm sufficiently senior to apply for silk at my bar. But my main aspiration is to come to the bench. If I were not appointed to the bench, eventually I'm sure I would apply for silk in the next few years. Yes, Commissioner.
Thank you. All right. You'll correct me if I'm wrong. Judge President Mulahle, he wouldn't press this issue with you, but I just got a hint of a sense that he has certain concerns. I even thought to myself, maybe he thinks you, well, he found you to be aloof, but there's just something that he would not come out and say. And I say this mindful of the fact that being a judge is one of the most solitary jobs in the world. And when you are acting as a judge, you have the added pressure of not wanting to put a foot wrong, and there's lots of work for judges. So keeping to oneself, you know, may not mean anything untoward. But I still would want, especially that you have not sat for any real period of time on the bench, I would still want reassurance from you that you understand the importance of collegiality on the bench.
Yes, thank you, Chief Justice. I really do understand that. I work best in groups. I don't particularly, one of the things I don't like about being an advocate is being all on my own. In Durban and Cape Town, it's very easy because there's only one other judge, and one goes to that judge's chambers in the morning, and it was Judge LaGrange usually in Cape Town, and it was Judge Witcher in Durban, and I had very good relations with both of them. Johannesburg was a completely different situation, and Chief Justice, yes, I felt that I was new, I was very junior. I didn't feel that I had the right to impose on anybody, so I just worked very hard in my bubble and tried to stay out of everybody's way. It was in no way intended, and I'm sorry that I seem to have come across as aloof. I'm absolutely not aloof. I'm very sociable and quite gregarious, and I absolutely understand the importance of that, and I value it enormously. As I say, it's much easier to work in a collegial environment where you can go to your colleagues and say, I've just had this difficult case, what would you do, or what do you think I should do in this instance? So I am somebody who prefers to work like that than alone, and I think that's one of the things that would be very enjoyable for me if I were to be appointed to the Johannesburg court, is that it is a big court with a lot of judges and a lot of scope for that sort of interaction. And I would enjoy that and benefit enormously from it.
All right. Last one. You and I are the same age, 61. Ooh, just gives me horrors just to say it. At some in this very room might consider that advanced age, which maybe it is, to be starting a new career path. If you are appointed, how long would you still have to serve on the bench?
Well, Chief Justice, as you will have seen, the GCB very kindly pointed out my age, and they counted for us that it would be 13 years and 9 months, I believe. And I think I have two things to say about that. The first is that, as I've mentioned, when I went back to university in my 40s, it was because I had the aspiration to become a judge. And from as early as 2015, I made that aspiration known, and I made it known that I was available to act, and I actively sought an acting appointment. But it was not to be, and it was only in 2021 that I was first given the opportunity. I would have loved to have done a lot more acting, and I would have loved to have come before this commission before today, but I was advised that until I had had a proper acting stint, I should not be thinking of applying for a judicial appointment. That's the first thing. And the second thing is that, well, now that we all know my age, I feel fine, I feel great, I feel full of energy. I'm happy to start a new chapter at this point. And I come from a very long-lived family My father was very vigorous and active until well into his 80s. And if I'm lucky, I'll be fortunate enough to follow that path, and I'll be in my right mind for many years to come, Chief Justice, hopefully.
No, thank you for saving our honor. Any further questions for the candidate colleagues? No? All right. That's the end of your interview then, Ms. Harvey. Anything you want to raise with us before you leave?
That's it, Chief Justice. Thank you for the opportunity.
You're excused.
Is that on or off? Good afternoon. I'm fine, thank you.
Good afternoon, Ms. Norton.
Good afternoon, Chief Justice.
How
Good
are you?
afternoon, Commissioners.
How are you?
I'm fine, thank you. I'm well, thank you.
Okay. You want to ask after my health?
Sorry, I missed that.
Well, in African culture, you exchange these cordialities. You are supposed to ask me.
Yes. Chief Justice,
In
how
return.
Shem, Chief Justice, how are you this afternoon?
Thank you. It's been a long day, but surviving.
Shem,
Thanks
yeah,
for
just-
asking.
All right. Thank you for the prompt.
You're an attorney of many years, currently a director in Kabela Huntley Attorneys
That's correct, Chief Justice.
since 2005,
That's correct.
and for about 10 years before that, you were with Chidel, Thompson and Hazen.
Yes, that's correct.
where you started as a candidate attorney and worked your way up to senior associate.
Yes, that's so.
You started out as a teacher.
Started out as a?
Teacher.
Yes, I did. Yeah, I qualified in education, and I worked in an adult basic education NGO for about 8 years, and then I moved over to law.
Why did you?
Yeah. The reason I did was adult basic education is unfortunately pretty much on the margins of the education sector. And I wanted to, explore other professional possibilities. And I think also around that time, which would have been early 1990s, there had been a certain expectation that there might be a large-scale, a mass literacy campaign post-1994. But in fact, the decision of the government was rather to invest in primary education, and quite frankly, I supported that. So I had a sense that my time in adult basic education was really coming to an end. And yeah, I started to study for an LLB, which I did through UNISA. And yeah, so I changed careers. But some of the basic principles of sort of redress and transformation in both kind of sectors broadly, philosophically, would be similar.
In addition to this LLB, you have 3 other academic qualifications. Well, 3. The BA, honors, and diploma in education that would have allowed you to work as a teacher.
Yes, that is so, yes.
And an LLM?
Yes.
In what area of the law?
In labour law. In labour law. I did that in 2009 at Wits, part-time.
All right. What kind of work do you do, mostly? Asking the obvious question.
Yeah, in my practice, it's quite all-encompassing in relation to labour law. I chair disciplinary inquiries. I represent clients in the CCMA. I also represent clients in the labour court, usually on reviews. I write HR policies. So really, I advise on strikes, collective issues. Basically, the full gamut in a way of what you would expect in a labour law practice. That's what I do, and obviously I train my juniors, my candidate attorneys, my associates. I play a role in the firm. Managing the firm and leading the firm. So I have a busy day.
Right. You've acted in the Labour Court intermittently since 2015. 2015, 2019, 2023, and last year?
Chief Justice, that's correct. All of those dates are correct, yes.
For a month per stint?
So at the end of 2023, it was for a month, and then I acted for the full term in 2024, the full first term of 2024, yeah.
So in all, you've acted for 4 months?
About 4.5 months, yes.
Which seems to be a concern for some of the professional bodies. What would you want to say about that, if anything?
Yeah, I've read the concern from the Black Lawyers Association, the sense that 4.5 months is not sufficient experience. And I appreciate that point, because I think the longer that one has experience acting, obviously the deeper your knowledge of how the processes work, etc., etc. but I really had a very rich experience as an acting judge, and I went back over all my various judgments, and I categorized approximately 16 different types of matters that I had presided over. Obviously, there were reviews, there were trials, there were contempt applications. I gave judgments ex tempore, restraint of trade issues, etc., etc. So, contractual disputes. So, during my time, I feel that I had a rich experience of the kind of disputes which would come before me as a permanent judge. So I do take the point. I appreciate the point. I do feel that I would be, if there was a novel issue that came before me, Chief Justice, I'm not a legal practitioner who busks. I'm just not. I make sure I'll have a look at the rules, I'll have a look at the case law, and I'll get on top of it. So I hear the concern, but I do feel that I would be able to competently judge the matters that came before me.
You have written judgments during your acting stints.
Chief Justice, sorry, I missed that.
You have written judgments.
Yes, I have.
During these acting stints, and you list 3 as being reported.
Yes, in fact there are 4, but there were 3 that came out of my term, in my first term in 2024. Yes, so there have been 4 reported judgments. The 3 most recent came out of the experience of acting for a term. Yes.
How many would you?
In all, okay, only 4 reported judgments, but in all, Chief Justice, probably, really over that time, probably about 40 or 50.
Were you able to deliver them within reasonable time?
Yes, Chief Justice, I got them all out. I'm very conscious of the 3-month rule. So I made sure that, yes, all my judgments came out within that time period. I have no outstanding judgments.
You've written articles in labor law which have been published. Count a few.
Yes, I have.
So writing is not an alien practice to you?
Maybe it's the teaching background, I'm not sure. But I do like to write. I do like to clarify issues if there are new issues in law. And usually what happens, Chief Justice, is I might be faced with a novel sort of legal point in my practice, and I do a whole lot of research, and maybe I'm drafting heads of argument, and what I realize is actually that not with too much work, you can really take some of the sort of affidavits or basically opinions that you've been drafting, and you have a look at what the requirements are of various law journals, and it doesn't take too much work actually to take the same sort of substantive body of your writing and just convert it into an article which could be in the ILJ, it could be in contemporary labor law, it could be South African labor bulletin. So really, I would have a look at my audience, I would look at the audience and the readership, and then think, well, would this particular opinion, with a little bit of adaptation, could it be published? And so, yes, I have, and I've also started to write articles, for example, in the Sunday Times, opinion pieces, just to get to a wider audience. And labor law impacts on so many relationships. The employment relationship. So I think it has a wider sort of interest span, if I can describe it like that. So yes, I do write.
All right. Would you tell us just briefly what happened in 2019 concerning the matter you disclosed in your questionnaire, which led to a director in your firm being struck off the roll and the rest being mulcted with fines?
Yeah, gosh, Chief Justice, that was...
And if that should be a consideration at all for us as we ponder, when we do ponder your eligibility for appointment.
Yeah. Thank you, Chief Justice. It was obviously an issue that I knew I would have to properly address in this forum. Basically, what happened was we had an aberrant director at our law firm who stole trust funds. He stole initially approximately 17 million from one client. The client came to the leadership in the firm and basically said, look, there's a problem. One of your directors has been stealing out of the trust fund. What he said was, I'm going to give this person an opportunity to recover the funds because it was a lot of money. And the aberrant director managed to recover about another 6 million. But essentially, at the end of the day, Chief Justice, we had a trust deficit of approximately 11 million rand. That was a lot of money. We reported the matter to the Law Society, and the Law Society came through to our offices, and they did a complete audit of our financial affairs, and they confirmed that there was a trust deficit of 11 million rand. The aberrant director obviously left the firm. He was subsequently struck off the roll. The Law Society then charged all the directors, there were 5 directors, and I was one of them, charged the directors with misconduct for failing to properly supervise our trust account. And we pleaded guilty to the charges. We sat before a disciplinary in front of the Law Society. We pleaded guilty. And we were fined certain amounts. I mean, if anyone is interested, I was fined 100,000 rand. I had to pay 50,000 rand, and that was the other 50,000 was suspended over 3 years. The other thing we did was that we then took out a loan from the bank, and we have paid off. So we took out a loan to cover the deficit in the trust account. And the deficit was covered, but we've had to pay back that loan. That was, that's part of the punishment. That's what we had to do to make good on our negligence. And obviously we set in motion certain processes in the law firm where we paid far greater attention to the trust fund and the transactions between that were happening, made sure that we were FICA compliant. So I would like to submit to the commissioners here and to yourself that it is something that I've learned from. I feel I've paid the price. And that to the extent there were transgressions from our side, that the nature of the transgressions were negligence. They weren't dishonesty. We weren't dishonest. And the Law Society has continued to issue Fidelity Fund certificates to all our directors every year. There was never 1 year in which the Law Society felt that we were not fit and proper persons to be in the legal profession. It was a deeply regrettable time of my life. I hope I've provided a decent synopsis for you to assess the situation.
Thank you, Ms. Norton. JP Mlehle.
Thank you, Chief Justice. Good afternoon, Ms. Norton.
Good afternoon, Judge President. How are you?
I'm fine, thank you, Sam.
Good.
I see in answering the question of your involvement in the labor matters, particularly in relation to the labor court, you say you occasionally appear in the labor court. And that seems to be supported by the number of cases you've listed under paragraph 6.4 of the form, where you ask reported cases in which you appeared as an instructing attorney. So your weight of work in the matters related to the labor court isn't that high. And you do say that most of your cases are, you litigate in the CCMA.
Yes.
Is that correct?
Judge President, that is correct. Let me clarify. Because it was also a concern raised by the Black Lawyers Association, and I went through my cases over the last 2 years. I just took 2 years, have a look at my record, and I appeared 10 times. So Judge President, I think when I listed those particular cases, I think those were in relation to reported cases where I've instructed counsel. Okay. They weren't, I certainly haven't only appeared 5 times over 20 years in the labor court, but I appear approximately every 2 months or so, and I did provide a schedule to my response to the BLA, really setting out the cases where I have personally appeared, and most of the time, Judge President, when I do appear in the labor court, I appear without counsel. I do it myself. And as I say, over the last 2 years, there were 10 occasions. So I think that's a reasonable, I think that's probably a reasonable average, approximately 5 cases a year.
And the nature of matters that you handle when you appear before the labor court?
Judge President, they're largely reviews, pretty much reviews, if I had to kind of categorize the nature of the matters before me, they would mainly be reviews, okay. Either initiating or defending.
Okay. And have you appeared before the Labor Appeal Court?
Judge President, I have, yes. I did. In 2023, it was Prasa versus Mahubi. It is a reported judgment. Yes, I have appeared in the LAC.
Did it go your way or the other way?
Unfortunately. No. Unfortunately, it didn't go my way. Okay. It had gone my way in the CCMA and the Labour Court, but when it got to the LAC, no, it didn't go my way.
Okay, thank you. And tell me, in the manual, we mentioned this issue about attending tea. What do you find as a value in attending the judge's tea?
Gosh, that is one question I could never have anticipated. But let me say, the value of attending judges' tea is you get to meet your colleagues and you hear about their matter. And if you have a matter that is troubling you or you need a little bit of advice, colleagues are very, very generous, actually, with their knowledge and their experience. As often as I could, I would attend the judge's tea.
And you seem not to have missed any one of them, at least for the time that I've always been in the tea room.
Yeah, no, I did attend.
Okay, thanks. And now in terms, and the Chief Justice put this to you about your acting stint. It's quite a short stint, isn't it?
Judge President, 4.5 months, I would have liked more, but I took the opportunities when the opportunities presented themselves. I've also, this is not as an acting position, but I've also spent quite a lot of time at the Labour Court in the pro bono clinic. And at times I'm asked to, go to court and represent an indigent employee. But yes, look, I can't take it much further. It's 4.5 months, and that's what it is.
In that period, did you do any urgent application and unopposed motion?
Yes. Oh, yeah. No, I did unopposed.
How did you find those courts?
Look, let me talk about the unopposed court. I found the volume. I must say, I found the volume of matters that I had to apply my mind to quite onerous, but I did manage. In the unopposed role, well, certainly when I was acting, there would be sometimes 30, 35 cases. So yes, I found the volume quite onerous, but I managed. I got through it. I obviously had to prepare. I think Monday is the day of preparation for judges, and I just read, prepare draft orders, etc. Urgent application, yes, I did have an experience of an urgent application in relation to an employee who wanted to expedite execution, and the employer brought an application, an urgent application to stay enforcement, and that was one of the matters that I heard on the urgent roll.
But you didn't do a full urgent court roll?
No, I didn't.
Oh, you didn't?
I didn't, Judge President, I didn't.
So I was going to ask you about whether you've ever used the court online system.
Yes. Judge President, we, obviously as a firm, we up, and my colleagues who are doing work in the civil courts, they're up and running. But I'm afraid to say that we have tried to register, and maybe this is not necessarily for this forum, but we keep getting a response that says something like your LPC number is irregular or whatever, and actually the LPC number is on the website. So we are following up, and I'm very aware, and I want to applaud you, Judge President. I do, because the Labour Court is going online, and I saw that there were new directives issued, I think maybe yesterday, for the 14th of April, and I think this is going to be a very transformative process in the Labour Court, that our pleadings will be served and filed online, and there's an opportunity to run matters online, and I think it will be of benefit also, because there will be an orderly way in which one can manage the pleadings. I must say, one of my challenges when I was acting is that you could get a couple of boxes in your chambers with a range of files in all sorts of condition, and you'd have to obviously make your way through them. But I do think that the court online is really the way in which to go. It's going to streamline processes, and I think it's absolutely the way to go. I'll just have to work a little bit harder with the LPC to make sure we can register. We have been trying.
But that issue you don't have to worry about. The technical people will help you.
Okay,
thank you. As soon as you contact the help desk, they'll sort you in less than 20 minutes, I can assure you.
Good to hear. Thank you,
okay.
Judge President.
The other question I wanted to ask you relates to how did you find the acting stint? Is it pressurizing? Is it easy? Were there fewer files given to you? Did it impact on your social life?
I'll get to that question maybe last. I found it invigorating, actually. I found it very stimulating to be presented with, two competing versions, and two different sets of arguments, and two different sets of facts or legal issues, and to hear the parties and to form a view on which way to go. I mean, we have an adversarial system. There is only one winner. But I need to sleep at night as well. So it was very important for me to be thoroughly prepared, to be able to engage with the parties who appeared before me, and to put my questions or my issues to the parties. And at the end of the day, if it was a complicated matter, I would reserve judgment, and I would take that file away and work on it maybe during recess or another period, and write the judgment. When I was in a position to give an extempore judgment, I would, but that was less so. So yes, invigorating. I quite enjoyed also going to Durban and getting a sense of some of the issues there. I went to Quebec twice. I got a sense of the different courts, and yeah, did it impact on my social life? A little bit, but it was fine. I like writing, and I like writing judgments, so I didn't mind, quite frankly.
I was going to ask you about traveling, but it seems like you have no problems in traveling.
No, I have no problems in traveling.
Have you conducted any cases through the virtual court?
No, I haven't.
No. And what is your view about the use of the virtual court?
Sorry, do you mean about the virtual court that we have now, or are you talking about running a case like during COVID?
Well, probably like running the case during COVID.
Okay.
Virtual is basically doing the case through the electronic distance,
yes.
electronic format.
Yes. Chief Justice, yes, I have. I ran a trial about the fairness of a large-scale retrenchment. And that happened during the COVID period, and yes, we did it online. Have I in relation to the new system in the Labour Court, the courts online, which began, I think, around about August 2020, August last year, Judge President? No, I haven't needed to. So my experience has largely been during the COVID period, where I represented a party and we did it online. Yeah.
Okay. And finally, from my side is you've referred us to two judgments that are published from your side, and one of them, the very first one, that NUPSO versus the CCMA, that's a DISCAM case.
Yes.
Refresh your memory.
Yes.
Now, that case, as I understand, you were dealing with the issue of firstly, let me check. Has that case gone on leave to appeal? Has it been appealed?
I think it's already been argued, but there hasn't been a decision yet.
On the appeal?
Yes, on the appeal, yes.
And you said that you've gone back to your judgments and looked at them. Have you looked at the judgment again and looked at how you articulated the principles and how you dealt with the application of the facts onto those principles, the legal principles?
Yes, I have.
And you're satisfied that you've covered the law and the facts in the manner that you would ordinarily do?
Yes, I am.
So it's actually a case dealing with the common purpose principle.
Yes.
And as I understand, those workers, they was on a legal strike. They traveled in a bus. They started singing in the bus, and as soon as they left the bus, others started committing unlawful conduct. But the others just didn't join in. They kept just singing. And you saying, in as far as that's concerned, it fit quite well into how you concluded on the, was it the two employees who were finally found not guilty of misconduct by the commissioner?
Yes, perhaps I can comment. Your question is kind of veering towards the common purpose. The two employees, those were a little bit tangential to the main case. And what I had to consider, Judge President, looking at Marley Pipe and the decision there. And basically the legal principle is that misconduct might be carried out by employees during a strike. Does that misconduct then flow to other employees who are not misconducting themselves? They are, in a way, the bystanders. They're just watching. Can the misconduct of the employees who are, maybe burning tires or stopping traffic or whatever it might be, can that misconduct be imputed to employees who are just watching, basically? And the legal answer is no, they can't. And that was the situation of the employees on the bus. About 70 or 80, maybe 50, I can't remember exactly the numbers, stayed on the bus whilst the majority of union members got off the bus and basically ransacked Dischem at Sunning Hill and at Woodmead. And the question then became, and so the dismissal in relation to those employees was clear. There was nothing controversial about that. But what about the employees on the bus who did not get off the bus and commit misconduct? And I found that the dismissal in relation to those employees should still stand. And the reason, Judge President, was that they had transgressed 2 court orders. So the one court order was in relation to picketing rules, and the second court order was an interdict to prevent employees from associating, from gathering, from continuing with protest action. So although the nuance of that case, Judge President, the nuance of that case was, it is true, those employees who sat on the bus and didn't get off the bus and didn't commit misconduct was distinguishable from those who did. However, they too had transgressed and broken 2 court orders, and I therefore found that the dismissal in relation to even the workers who sat on the bus and sang struggle songs, that their dismissal was justified.
Look, I guess what confuses me is your reasoning in paragraph 72 of the judgment. You found these employees did not participate in the unlawful conduct. That's your first finding. But then you say by singing the struggle songs, you found also that singing the struggle songs did not constitute misconduct. But then you say their action, and I quote here, you say, does indicate allegiance to misconduct. That's where I found it a bit confusing for me.
Okay. That wasn't part of my decision about whether or not their dismissal should stand. It was really just a comment that, first of all, I wanted to say that singing struggle songs doesn't mean that you pass the threshold into misconduct. You don't pass the threshold into common purpose. It is really, struggle songs are part of service delivery protests, they're part of labor protests, etc., etc. So I said, I found that even though there was sympathy, that doesn't prove allegiance with what had transpired. But the rationale for why their dismissal should stand was the breach of 2 court orders. And that turned it for me.
Thank you very much. Thank you, Chief Justice.
Thank you, JP. Okay, network colleagues first if they have any questions. Okay. Commissioner Marumakhai, followed by Commissioner Mangena.
Thank you very much, CJ. Good afternoon.
Good afternoon, Commissioner.
I just want to follow up on the judgment that the JP has just taken you through. But mine is it's quite a sort of a different angle. And obviously it appears on page 45 of your pack. There were about 2,500 employees who went on strike, and about 800 employees were dismissed. Now, as I understand the judgment, there were three issues that you had to deal with. The first two are including the parity. Let's put it aside and deal with the common purpose issue. And in your judgment, you correctly rely on the dicta of the Constitutional Court in Ndludlu, where Matlanga J set out what should be understood, I guess, as a test for common purpose in the context of labor law.
Yeah.
And in the context of dismissals. Yeah. What I don't kind of like understand in the application of common purpose, because it appears as if the test of common purpose in labor law is different from how we understand it in criminal law, the way it has been set out. So now you have just said that there were 50 or so employees in the bus, and when you apply the test, those employees were not associating in the misconduct, hence they could be excluded. But what I want to understand is, if you have a group of employees, the way in which you apply this test out, are you looking at employees individually, or are you looking at employees as a group? In other words, you are saying the group of employees on the bus, or is it every single employee to look at their actual conduct in relation to the alleged misconduct to justify whether or not the dismissal was fair? What is the actual application of this test?
Yeah, I think when it comes to common purpose, you have to associate. So you must, in order to be brought within association with the misconduct. And that makes things very onerous for employers, but that's the way it is. That's the law as it stands. You have to be in order to impute misconduct, you have to be able to show the evidence that demonstrates that that particular employee associated with the primary misconduct that was happening. So I think that's the test. In relation to the employees on the bus, my point was they didn't associate. They didn't associate. That singing struggle songs is not an indication of association. Maybe it's an indication of support and comradely support, but it's not an indication. It doesn't satisfy the test of association. So I did not find that those employees who stayed on the bus and sang struggle songs, that they had crossed the threshold into association with the employees who had misconducted themselves. So then you might ask the question, well, why did I, despite that finding, decide to uphold the CCMA Commissioner's ruling on the fairness of the dismissal? And I did so because they had breached 2 court orders. They weren't supposed to be on the bus at all. None of the employees, they were interdicted from assembly, from gatherings and continuing with with strike protest action. They had been interdicted from doing that. That was the second court order, and the first court order that they had breached was a breach of the picketing rules. So on the basis of the breach of those two court orders, I sustained the finding that the dismissal was fair. I hope I've answered your question, Commissioner.
Can I please follow up, CJ?
Okay.
I hear what you are saying, and you are probably right. But my concern is not on the order that you made or the conclusion that you reached. Perhaps what I'm trying to debate with you on is the actual common purpose and how it should be applied. I don't even have the answer myself. I just want to get how you view this, because I'm looking at you laid out the test in paragraph 65 as laid out by the Constitutional Court, and what follows therefrom. Then you have a subheading that says application of the law to the facts, and then you revert to all the two other issues that you are dealing with. And that's where my concern, because I want to understand your understanding of common purpose, because when I read the judgment, it doesn't appear to me that perhaps, or it doesn't give me a sense that you applied the test as you actually quoted it. So that's where I'm trying to, and I'm not saying you are wrong, because I don't even know the answer myself. I just want to understand how common purpose should be applicable or should be applied in the context of labor law.
Commissioner, I mean, essentially what you have is primary misconduct perpetrated by, say, a group of workers during a strike. We know what it looks like. You know, perhaps burning of tires, barricading, rocks, etc., etc. So let me say you have a group, I'm going to call them the primary kind of workers doing the misconduct. Primary misconduct happens there. What is the situation in relation to the workers who are really just standing around and watching? Should the misconduct of those primary employees be imputed to the secondary employees, if I can just use that kind of language? The Constitutional Court says no, that it can't. That unless individuals in that secondary group show active association by maybe joining the primary group, doing what those employees are doing, unless there's active association with the misconduct that is taking place by those primary employees, those employees, the secondary employees, I'm just using that kind of label, cannot be found guilty of common purpose.
No, thank you. Thank you, CJ.
Commissioner Mangan.
Thank you, Chief Justice. Good afternoon, Advocate or Ms. Norton.
Good afternoon, Commissioner.
We've been talking to advocates greater part of the morning. I'm adequately covered with regard to common purpose, but I want to check with you the application of the parity principle. You'd recall that some of the employees were actually given final written warning when others were dismissed. And in your judgment or in your order, you actually agreed with the employer that the inconsistency doesn't matter. But my issue is with your reasoning. You say that the employer was actually cannot be faulted for different sanctions because there were different chairpersons who had the internal disciplinary hearing. As I understand it, discipline is the responsibility of the employer. When employees complain about inconsistent application of discipline, they are saying that the employer imposed different sanctions for same misconduct. So it doesn't really matter at times who the chairperson was.
All right, that's a good observation. Let me explain my reasoning. So as we know with the parity principle, that like misconduct attracts like sanction. That's a notion of fairness, that if person A has committed the same misconduct as person B, they should both get the same sanction, basically. I mean, that is the idea of parity. What had happened in the strike is that there were about, 300 or so employees. 800, let's just put it like this, 800 employees were dismissed after the strike. But the number of employees who were part of the case that I had to review, about 250 workers had been dismissed. And what I understood from the record is that Dis-Chem conducted group disciplinary inquiries where there was consent by those workers to be part of a group disciplinary, and where there wasn't consent, there were individual disciplinary inquiries. And inevitably, when you have a multitude of chairpersons, you're going to get a range of sanctions that are reasonable. So you can't, because you don't have one chairperson who's hearing a case for 250 workers, there were many, many cases. And because you had different chairpersons, and sometimes, Commissioner, different extenuating circumstances, because we know when it comes to sanction, that a person's personal circumstances are also taken into account. Is this an employee of long standing? Has the employee in the past won employee of the month or whatever? There might be, from the different employees, different reasons, although they've committed the same misconduct, their personal circumstances might present mitigating and extenuating factors to encourage a chairperson to not grant the ultimate sanction of dismissal, but perhaps to grant, to impose a sanction of final written warning. So I think in a situation where you have large scale, a large number of disciplinary inquiries taking place, inevitably there are going to be some differences in terms of the sanction that is imposed. And I didn't find that having those differences really detracted from the principle, from the parity principle. It was a consequence of the large number, and perhaps the personal circumstances that were presented to the chairperson who arrived at a finding not of a dismissal. And I think it only happened in relation to 2 employees, but a final written warning. And that I thought I was sufficiently satisfied because of the flexibility that had been applied.
Thank you, Ms. Norton. Coming back to the unfortunate incident in the law firm regarding the loss of trust funds. You responded to the LSSA comment where you sought to explain yourself sufficiently in terms of what happened in the law firm. In that response, you say that Mr. Mkhabela was informed in December 2014 about the misappropriation of the trust funds. You recall that part?
Yes, yes, I do.
And then the firm, you self-reported through Mr. Mkhabela to the then Law Society of the Northern Provinces on the 30th of August 2017. There was a lapse of about 2 years, 2015, or 3 years, so to speak. A lapse of about 3 years in getting this matter reported to the Law Society. Why was that so?
It shouldn't have been. We shouldn't have waited 3 years. That was an error of judgment. But we delayed because the aberrant director was trying to recover the funds and the client who had been prejudiced by the theft was prepared to give him that leeway. But when it became really apparent that he couldn't fill that hole in the trust account, in the trust account, we then approached the Law Society, and in fact one of the charges, Commissioner, related precisely to the delay that you're talking about, and we pleaded guilty.
In 2015, did you get the Fidelity Fund certificate?
Yes, we did.
While there was still a trust shortfall?
Yes, we did.
In 2016, you got a Fidelity Fund certificate while there was still a shortfall?
Yes.
And you got the Fidelity Fund certificate out of the representations that you made that your trust account was in order when you knew that it was not in order?
Commissioner, remember we took out a loan and we filled the trust account.
Yeah, but when did you take the loan?
When did we take out the loan? Gosh, Commissioner, honestly, I really can't recall when we took out the loan, but we knew that deficit had to be covered. And we took out a loan, Standard Bank, and that's how we dealt with it.
Ms. Norton, on the 30th of August, when you reported to the Law Society, as at that time, you were reporting because the trust account was still in deficit.
Yeah, Commissioner, honestly, I can't recall when we took out the loan, but we did. We filled the gap, and as I say, we were charged by the Law Society. We pleaded guilty, and that was that was the way we dealt with it. Could we have done it better another time round? Hopefully there'll never be another time around. But that's how we dealt with it.
So the 2 years that you did not report it, you had hoped that the aberrant
regret. And you know, the firm, to the extent it could, it made good. It made good by admitting guilt to the Law Society. We made good by paying the fine. We made good by personally taking out a large loan from a bank to cover that deficit. We made good by pursuing criminal charges against the aberrant director. And I, you know, there was, I'm not quite sure what else we could have done. And obviously internally we had a look at our financial systems and ways in which those could be, you know, improved so with respect, Minister, I accept the chastisement. And you know, I don't think it necessarily detracts from my integrity. You know, this was a crisis in an emerging firm that we tried as best as we could to manage, which we did. And I take the criticism about us not disclosing at that particular time. And yes, we did hope that this aberrant director would make good on what he had stolen. But when it became clear that he wasn't going to, we did the right thing. Minister, I don't think I can take it much further. I'm not unprepared. I'm very prepared. And I did go through the various dates. I put them in the letter. I can't really take the matter much further. It's really here.
What do you mean you didn't want to identify anybody?
Well, Chief Justice, I didn't want to mention the name of the aberrant director.
Why not?
Why not? Because, I don't know, I just, you know, I don't know why. Protect his dignity. I don't know why. Yeah. So in the initial response in the questionnaire, I wrote more generally. But when the Law Society requested greater explanation, I put the names.
Commissioner Matolo-Dlebo.
Thank you, CJ. I'll let it pass. Thank you.
Commissioner Malem.
No, I just want to ask, for you to get the Fidelity Fund certificate, what is required?
An audited report.
No, for you to get, for the trust to get the Fidelity Fund certificate, what do you do? What do you submit to who?
You submit your auditor's report, which goes to the Law Society.
Thank you. So it means you knew about this in 2014, 2015, 2016. You say to the Fidelity Fund, the people who issue a Fidelity Fund certificate, our books are in order. So in a way, you deliberately misled those people. Leave the fact that the funds were stolen and all of that, you reported that, you regretted that. What about this misrepresentation before the body that gives you Fidelity Fund certificate? Because there is no way you had told them this truth that you said you told the Law Society. Otherwise, they were not going to give you, I suspect, the Fidelity Fund certificate. And after that, all these years, you remember that 2016, he asked you, 2016, did you get Fidelity certificate? You say yes. 2017, 2016, did you get a Fidelity Fund certificate? You say yes. When did you get the loan? That one I don't remember. You remember the things that have got nothing to do with you, but the one that has got to do with you, which is a loan. Not a certificate, because you don't issue certificates. But those ones you remember. But as in when did we get the money so that we qualify to get the Fidelity Fund certificate, you don't remember. And I agree with you. You came prepared. You are prepared. You just prepared to come and distort this fact because you knew it's going to rise. It's not a fact that we're not going to raise it. You knew, and one of the facts that we're going to deal with is, when did you get the loan? So you know, if you give us the date of the loan, it's going to contradict the financial year of 2015, 2016, where you got the Fidelity Fund certificate. Am I correct in my observation?
Commissioner, I can't take the facts much further than I have explained and that I've written. You know,
Justice, can I just add something to that as well? And I'm sorry to do this because I know we're out of time.
Okay.
But I need to put this to you, Ms. Norton, because for me it's a matter of serious concern.
Okay.
In your answer to Commissioner Mangena, when he asked you about the 2016 and 2015 certificate, Fidelity Fund certificate, your answer was, but we had gotten a loan to repay.
Yeah.
Right? But in your letter, you make it very clear in item 10 of your letter that in November 2017, a legal official from the Law Society had found that there's a deficit of over 11 million rand in the trust account, which means it makes it very clear that whatever loan was procured was done after November 2017. So I have to raise with you that I've got serious concerns about the answer you gave.
The logic of that, I would agree, yeah.
CJ,
stands.
CJ, my point is very simple. There are two wrongs you have done. A person stole the money, you didn't report it, and ultimately you went to plead guilty about that specific issue, which you say, that I admit. I want you to admit to the second issue, that you deliberately misrepresented the facts in order to get a fertility fund certificate, which is a separate misconduct on its own. That you cannot misrepresent the funds of the trust, even when you know there is a deficit. You cook books and then you get the certificate. That only, and this, the Law Society didn't deal with it. It dealt with you not reporting the stolen money. What about the fact that we just established now that leave the money being stolen, even the books were not properly recorded and there was misrepresentation. That's why they got Fidelity Fund certificate throughout, even when they had a deficit. Am I right?
Yeah.
Thank you, CJ.
Commissioner Bredenbach.
Thank you, Chief Justice. Good afternoon. I'm over here.
Oh, yes.
What happened to Mr., how do you pronounce his name, Adekeye?
Yeah, so there's a criminal case against Mr. Adekaya.
It's 2025,
I know.
It's finalized.
I know, it hasn't. It's at the Palm Ridge Magistrates Court. It has been ongoing for about 4 years or so. And the criminal, he was struck off the roll. Okay.
Yes, in 2019.
Yeah.
When did you lay the charges?
In around about the same time, when all these disclosures were made, we laid criminal charges against him, but the case has taken a long time. It's still ongoing.
And if he had repaid the money, would you have laid criminal charges? Try hard to give a decent answer.
No. We probably would have. We probably would have.
Probably is going to sink you. Thank you.
I think Commissioner Breitenbach is finished. Commissioner Breitenbach, do you know what happened to Mr. Adekeye? You should know.
I don't. I'm not a prosecutor and I haven't been since 2013. But you can be sure that I will now go and find out.
I just have one point, Ms. Norton. I mean, look, I hear what all of the commissioners have put to you, but not to detract from them. But I have a narrower problem, which is that you've been drip-feeding us the disclosures, which is fully within your control. I understand the others that it was a partnership and you guys were also a victim of crime. But the problem is that your disclosures to us as the commission, have been coming in drips and drabs. and this is the problem I have about being drip-fed information. I happen to sit in the objections committee, and we read through these objections. If it had not been for the Law Society, you know, the sort of mundane disclosures you made would not have made me worried. But it's because the Law Society dragged the information out of you that I actually got to know that this is a very, very big thing that we are dealing with. So I just thought maybe you want to comment about why you have been drip-feeding the Commission with your disclosures.
Commissioner, I didn't feel that I was drip-feeding. In the questionnaire, I made the disclosure. I gave some background to it. Quite frankly, I didn't know how much detail to provide. And when the Law Society came back they said there hasn't been sufficient information or disclosure, I went back into our records and I provided what I thought would be a sufficient disclosure. Gosh, if it feels drip feeding, that's certainly not my intention. Yeah, I think you know, a matter like this also creates a lot of interest and a lot of curiosity. But I don't think I was drip feeding. I made the key disclosures and the key apologies. Yeah, I can't really take it much further than that.
No, I understand. Thank you.
Thank you.
Even that, I have some difficulties just on us. I just felt I was being misled, or I was not being told the full story, and it frustrated me. Because even the story about when exactly you reported Mr. Adike, the crime happened in 2014. And my understanding is that he was not reported at least until 2017. Now, that for me is a big problem. That you are a victim of crime, someone has stolen 17 million rands of a client's money, you are bargaining with them. But that disclosure, you know, was also not pertinently made, that there was a delay in the reporting of the crime. You know. So it's emerging now with Commissioner Malema, Commissioner Breitenbach, and Commissioner Mangen. This is the drip feeding I'm complaining about.
Yeah, look, I mean, we managed the situation as best as we could. You know, I'm a...
No, don't misunderstand me. I'm not complaining about what happened at the firm.
Yeah.
I understand you are a victim of crime. I'm talking about things you are in control of as an applicant to the JSC.
Well, Commissioner, if the feeling is that the disclosure wasn't sufficient, I apologize for that. I mean, I thought, you know, I'd given the details that was appropriate. Yeah, I can't really take it much further. Can I also say, I mean, this was a situation that arose many, many years ago. I'm also one of 5 directors. I certainly learned what the principle of joint and several liability meant coming out of this experience. But it has been a long time. And I have done also very, you know, good work in pro bono clinics and done pro bono work. You know, this is an unfortunate stain, and it really took us all by surprise.
Thank you, Sitri.
Thank you.
Thank you, Ms. Norton. You're excused.
Anything further?
No,
No.
I've just excused you.
Is that enough? Okay. All right. Thank you for the opportunity, and thank you.
Shall we clear the room, please, for deliberations? And while we do that, colleagues, Judge President Mulahlehi and his NETLEC team have asked for a brief period to caucus. I can't think of a better word, to caucus before they they come and give us their view on.
Can we walk?
Sorry. So how long do you need, JP?
I think CJ, not too long, 10 minutes at most.
All right. We can stretch our legs and
Thank you, sir.
have tea and come back in 10 minutes, 20 to 5. Oh, it's going to be long if they